Lord,
Your Ladyship, the matter yesterday was specifically assigned for today, and the matter is still not listed, my lord. My lord, it's a matter of extreme urgency wherein the respondent bank is about to take possession of the property.
The court.
Please, at 7 o'clock in the yesterday evening, 7 o'clock, it was removed from the list.
So which list?
From the other court, from court hall 12's list, it was
So
deleted.
what to do now?
Lord, a matter of great urgency, my lord.
That's not the problem of the court.
Their error.
Court has given a date.
Please, my lord.
So for whatever it is, it's for you have to go before the registry and say whether it's CPC matter or DRT matter.
No, it is a DRT matter, my lord. The staff has committed error.
Anyhow, that's not a problem of the court. Give the memo to the court officer. They'll call for the file.
Please, my lord.
But your lordships kindly.
No mentions. Please give the slips to the court officer. Yes.
Lord, this is the case, Lord. The threat of dispossession, Lord. This is a threat of dispossession from this residential house, Lord. That Monday, Lord, because some urgency, because Lord, the order was passed on 6/10.
Every day I'm telling, if you write the urgency and give,
That
I'm looking at the urgency.
Order was passed on 10.
I am looking at the urgency and assigning the dates. So
Threat of dispossession, I mentioned specifically that threat of dispossession from the
so that I
residential
will
house.
read. I can read at 1:30 and I can give the date still for Monday. So that's why I do not want
Because
anybody to make
earlier
a
also, I moved the memo.
If you have moved the memo, you please ask the court of, are you uploading it? Immediately, the moment you give the memo, looking at it, I am writing a date on that. If the urgency is not mentioned, I am also writing on the memo that urgency not mentioned. Then that will go to the section. There you have to verify. So earlier memo of yours, what has happened to that? You should have verified in the registry.
This court has given because the officer has raised the objection, one minor objection that also complete. Thereafter, the matter has not been posted. Only minor objection that authorized officer or manager. Authorized officer that was mentioned. Only oblique manager was not mentioned. That is only the office objection.
What I am requesting the advocates is, instead of wasting the court's time by mentioning and hearing everybody, if you write the urgency every day at 1:30, I am reading all the memos and I am assigning a date basing on the urgency. That's what I am telling. So there is no reason to mention, and I will not grant any lunch motions. That's very clear. Yes. Yes. Call the list. And if the urgency is not mentioned, I will not. I'll not assign any date. Yes.
My lords, serial number 7, my lords. Kindly have it on Tuesday, my lords.
Serial number 8. Who moved the memo?
We are moved.
My lords, the petitioner is in possession of certain documents, my lords. He's reaching tomorrow. We moved the memo on Monday, my lords. We had requested the court to list the matter on Monday, but it has been listed today. Kindly have it on Tuesday, my lords, because we are expecting certain documents and the petitioner is reaching only tomorrow.
Court should, like, whenever you ask, court can't post the matters. This is matter on November 12th.
My lords, Tuesday,
my lord.
No. Yes.
No.
My lord, 8, my lord, serial number 8. My lord, senior is not in station. Kindly have it on Monday, my lord.
Serial number?
8, my lord, 8.
In list number?
2, my lord.
My lords, I'm for the petitioner. My lords, I object, my lords, because last time, yes.
My lord, senior not in station, my lord. Kindly.
To do. If he has urgency, we have to hear him. Yes,
Lord, kindly have it on Monday, my lord. Please, my lord. Kindly have it on Monday, my lord.
You appear for whom?
Respondent bank, my lord.
Why you have not complied with the office objections in a matter of 2024?
Well, the office objections have been complied, and after that only the matter is posted before the.
Yours is eight.
Yes, I am for
Then
the.
it says non-compliance of office objections.
No, Malats, I have complied it, and after that only the notice has been issued and the K-weight has been served to the bank. And I think those office objections have not been.
This is matter on, what is urgency in this matter?
Malats, there is an interim order, and the Honorable Court has heard it on day before yesterday. Malats, the simple issue is only the condemnation of delay has been rejected by the DRT. Malats, that too 5 days delay, and the date of knowledge.
So why can't it wait till Monday?
Yes, Monday, but well, this honorable court on Thursday had told that on Saturday I'll dispose it of. So that that's why.
Then because it's all your colleagues' inconvenience that you have to consider.
No, Malats,
Next, on Monday,
Malats, interim order may be extended.
interim order is granted.
Yes.
Interim order earlier granted is extended till then, yes.
John, if I could just mention item number 8 in cause list 1. Your Honor, we are seeking a short accommodation on that matter. If that could be listed in the
Have you
first week
informed
of
the other
March.
side?
Yes, my
Yes,
lord.
Your Honor, they are there.
Objection.
Your Honor, if it could be listed on 5th or
List on November 18th.
Please, my lord.
please. Your Honor.
8. This one.
Yes, list 2.
Page 17, Your Lordship. 2 weeks of time may kindly be accommodated. The other side have also been informed.
You have an interim order.
Yes, please, Your
Why
Lordship.
should be accommodated?
Lordship, we are working on a settlement with the bank. We are ready to pay the amount as well.
They are ready to pay the amount, entire amount.
This is matter on 25th of November.
Please, Your Lordship.
At the request of
21, my
counsel,
lord.
the petition.
Serial number 21.
Huh?
Appearing for serial number 20,
Huh.
appearing for petition, senior natural matter, and lay out a next week any date.
Who appears for the respondent?
For responding, my lord. No interim order.
Huh?
No interim order.
No interim order. This is matter on 8th of December.
21, my lord. I am for respondent, my lord. Senior not in station. Kindly have it on next week.
What about the petitioner? I have to inform him. Wait till you. Any interim order in this?
I don't know, my lord.
Huh?
I don't know, my lord.
Yes, call the next list.
My lord, serial number 1 and list number 3.
Yes,
My lord, serial number 1 and list number 3, my lords, I seek for a week's accommodation, my lords.
dismissal matters you cannot mention. Next.
My lords, there's a family emergency, my lords. I am the proxy counsel for the petitioner in serial number 1, my lords. Kindly have it next week, my lords.
Yet request. This is matter on Tuesday. Yes.
Please, my lords.
I don't think there will be any adjournments in this list. Call the list. What is this? No, on the last occasion, you placed before this court an order where the order itself reads that a detailed, where is that? Come to the impugn order. It's unfair on the part of the advocate. Please come to the impugn order. Where is the order? Annexure E. Come to Annexure E. Page 44. There is a separate order that you don't file conveniently. Look at it on the top of it. Orders pronounced in the open court as follows. Wide separate order. That separate order you don't file. When the matter came up on the last occasion, because the judge has not considered the judgment of Rashish versus Neha, and there is no reasoning given by the court for passing such an order, I have remanded. Then I have asked the R&S to find out why these kind of orders are passed. Then there is a detailed order passed by him where he has considered everything. So then this order needs to go. I'll set aside this order and I have to confirm with the looking at the detailed order that is placed before the court. Where is your senior? Ask him to come. Pass out. No, but how can you file such an order when there is a separate order? Yes, next.
May I please, Your Lordship?
Yes.
In this matter, Your Lordships asked both the parties to appear before Nimans, my lord. Accordingly, the parties have appeared before Nimans. The doctors have asked them to admit for a month, my lord, which is not possible for the mother. On the last date of hearing, Your Lordships asked to get instructions from our client, my lord. I've got instructions from our client, my lord. It is very difficult for her because the child is aged about 3 years, my lord. Leaving the child at this tender age, it is very difficult for her to admit, my lord. However, she'll attend the mediation, couple counseling, my lord, from morning to evening or whenever the doctor suggests. Then she'll head back towards home, and then whenever the doctor suggests, she'll come and she'll attend, my lord.
No, unfortunately, the difficulty is we cannot tell the doctors how do you diagnose
Please,
the problem.
please, my lord.
Because that's not for the court, nor for the advocate, nor for the party to say
Please.
how it should happen.
Please, my lord.
If really she's interested, she is in terms of, she's looking for a solution, it has to be how it has to be.
Right. As a matter of fact, my lord, already 2 couple counseling has been held, my lord, by both the parties. However, the
And it's of
respondent
no
has not.
use. It's of no use.
Please, my lord, the counselor, the mediator has said that he has to change some certain
Say
elements, my
that
lord.
something is
But
wrong with the father. You say that something is wrong with the father, father says something is wrong with the mother. Who will
Please.
say that?
please,
It's
no, my
not
lord,
for, nobody has the expertise to say.
please,
And
absolutely.
we cannot tell the doctors, don't do it that way. We want it, if
Please,
the
ma'am.
treatment is something else, we say that's not acceptable to me, do it in some other way. How is it possible?
Please, no, my lord. The apprehension for the doctors is that, my lord, whenever the direction from this honorable court, the parties may not attend the couple counseling is what their apprehension is that, my lord. They will leave the premises or they will not attend for the sake of the treatment, my lord. That's the reason they make them admit at the hospital, my lord.
They said so.
Please, my lord. The
Ask
conversation
them,
is,
what is it?
please, my lord. My party has been appeared on the last date of occasion before Nimans, my lord. That's the verdict which they have given to us.
Then I'll ask them if it is so.
Please, my lord.
Please come. On the last occasion, on so and so, this court has directed on 17/10/2025. This court has directed the parties to appear. No, where is that order? No, this is not the order. This is not passed in this case.
It is passed in 2.1.
23.9, my lord.
Yes.
Uh,
Other
2.2.
503.
2.2.
2.2. What is the date of order?
23/9, my lordship.
This is not by this court, it is by the other court. You will have one more docket.
2.3, 14503. 14503, writ petition. Please.
This court has passed an order on 23/9/2025. Directing both the parties to appear before the doctors at NIMHANS on 16/10/2025, and the doctors shall evaluate both of them. As per the advice of the doctor, the party shall go through the therapy sessions. When counsel appearing for the mother submits that the parties have appeared, however, the doctors have insisted them to admit as inpatients for 1 month. It is submitted that the age of the child is 3 years, as difficult for the mother to admit in the hospital. It is also submitted that the couple counseling can be done. They can do the couple counseling, but it is the doctors at NIMHANS have expressed that the apprehension that they may not regularly turn up for the sessions. As such, they insist the parties to get admitted in the hospital. When counsel appearing for the petitioner submits that the mother is ready to go, ready to appear before, ready to go through the counseling, but as inpatient, it is difficult.
My lords, point number 1, the doctor, I also went to the NIMHANS last week. The doctor said the child can also come. There is no problem. First point. Second point, this particular thing that couples counseling was never mentioned to me, to the best of my knowledge. It's 2 small points.
Because it is actually not about, couple counseling. It is about, according to you, his state of mind is not normal. That's what is your client's case, isn't it? So how does a couple counseling will help? According to him, your client's state of mind is not normal.
What has happened, my lord? My respectful submission is that even previous couple counseling or therapists which they have been to, my lord, they have suggested some changes which he has to inculcate, my lord, which he is not doing, my lord. In turn, he is blaming, my lord. Till now, each and everything, my lord, may I submit this, my lord, even with the doctors, my lord. Till now, he has consulted 15 pediatricians in the town, my lord.
Let's
Each
not
and
go
every
into all that.
not the,
That's over.
my lord,
That's over. That
my,
phase is
my lord,
over.
that's the reason, my lord. My lord, even the advocates, my lord, once he is engaging the counseling, my lord, when the orders which has not passed in his favor, my lord, now he is appearing in party in person and is filing any applications, my lord. And he's also blaming the advocates as well, my lord, in the application. That's the reason with his, my lord. Even
That's
as
the
of
reason
now.
she'll not go.
No, my lord, there's a, no,
So
each
let's
and every,
not go into
no,
it.
that's
Now,
not,
please confine to how do you settle this problem? What is the solution?
Lord, no,
The solution is how do these people, what is their problem? How the doctors will diagnose? How will they go ahead with the treatment? That's the only issue now.
Please, Lord.
Let's not, let's just stop this, this blame game. Yes.
No, my lord, not at all, my lord. We are not coming in the way of, father
So
interacting with
what
the child.
I'm asking is this couple counseling is completely different from evaluating them. What is their problem?
Please, my lord, his apprehension is that whenever the mother says, she is not ready to admit, then he is ready, I'll admit that, my lord. It is also very difficult for her to travel for entire 2 hours, my lord, from her residence to the hospital. But
What is the distance between both the places?
20 kilometers, my lord.
What about him?
Same place, my lord.
Because she has to, my lord, ultimately she has to take care of the child, my lord. Even at times when she comes to the court, my lord, it is difficult for her to.
What we will do is, no, that is not possible for her.
Please,
so let's not take into consideration any of your submission with regard to these issues. Then we will independently pass an order then. That's the only solution. What to do? You're not ready. You say that the hospital is far off. I cannot go. I can't admit myself into the hospital. And husband shouldn't have you yourself will diagnose that he has some problem.
Lord, even the earlier 2 couple counseling, my lord, which they
Forget
have
about couple
even
counseling.
he only suggested that, my lord.
What is that we are going
The
to do
therapist,
now?
my lord, the therapist even he only suggested the doctors, my lord, which ultimately mother has been to both the couple counseling, my lord.
My lord, there was nothing suggested, no prescription, no report given by any couples counseling psychologists. In fact, I try to take her and try to amicably solve. We will not go into that, my lord. There is a child and his future at stake. This is your own honorable court's considered opinion that we should go. And the doctors, after doing an assessment, the psychiatrists at Nimans, the best hospital in India, after the assessment, it was their opinion that it is necessary for us to get this thing. And keeping the child's best interest in mind, whatever decision your lordship takes, I will submit to that, my lord.
No, my lord. My respect, even before evaluation, at the time when they reported before Nimans, my lord, the first thing they told was they should get admitted for an entire month as inpatients. She'll appear as an outpatient, my lord, because it is difficult for her to leave the child entire day and night, my lord. And at this tender age, admitting the child to the Nimans is very much difficult for her, my lord.
My lord, the doctors told the child can be brought into Nimans. No problem with that.
In all the cases, wherever the court is asking the doctors for evaluation, in each and every case, the doctors are asking the patients to asking and the doctors are suggesting that they should be admitted as inpatient. The director enhance suggest what is the best alternative apart from getting admitted in the hospital. The registrar judiciary is directed to communicate this order and a report shall be placed before this court.
My lords, if I may kindly just, if you look at the history of both parties, my lords, it's better if we, because
this matter on 4th of November, by the time a report shall be placed before the court.
Please, grateful.
Much obliged.
I appear for the petition, my lord, challenging the interim order passed by the trial court.
What is the amount granted?
My lord, 7,000 towards the maintenance and 5,000 towards the litigation expenses.
7,000. What is your income?
My, as per the page number 40, my lord, 14,902.
14,000?
902. Apart from that, I also have the liabilities up to 16 lakhs 25,000.
40,000 or 14,000?
14,000, 14.
Let's please come to the order.
The petitioner is entitled for interim maintenance to the tune of 7,000 per month from the respondent from the date of application pending disposal of the above petition. Further, the respondent is hereby directed to pay rupees 5,000 to the petitioners towards the interim litigation expenses. That is the order.
Then counsel the petitioner submits that the income of the petitioner is 14,902. And the court had granted maintenance of an amount of rupees 7,000. It is submitted that he has several liabilities. Considering the same, they shall be stay of all further proceedings on the condition that he shall pay 5,000 per month and arrears also at 5,000 within a period of 8 weeks from today. Either of the orders is not complied with. The stay granted by this court stands vacated. He shall take out hand summons on the counsel appearing for the respondent and shall file a memo to the effect by 17th of November. If the memo is not filed, even on that ground, the stay granted by this court stands vacated. Next.
Great.
Yes. Where is the impugned order?
Pardon?
Where is the impugned order?
Impugned order is at page number 43 to 49. 43.
Objections raised by the judgment debtor to the main petition are overruled. Decree holder is entitled for the educational expenses paid by her towards educational expenses of the child for the academic year in accordance with the receipts. Yes.
Look, it is actually earlier they were husband and wife, and they got divorced by way of 13B application.
Yes.
Now I take this honorable court to 13B application what we have filed. That is,
Before that, we will see what are your objections to the main petition.
main petition is that is in the middle before and the pending of the case. I have
Come to page 41. Let's read this.
Page
so that the
number
court will
41.
understand.
objections.
So
Page-
the objections that are your objections to the petition are that before spending the amount, she has not informed you, and whatever the amounts that she is mentioning, they do not, they are not supported by any documents.
I
That's
have not
objection.
given this thing. But one more thing I would like to bring this to this honorable court is that I have already paid 5 lakhs during the pendency.
That you should have stated in your objection.
That I have stated, my lord.
Where did you state?
In the third paragraph,
Hmm.
the judgment debtor submits that decree holder has not intimated the judgment debtor before paying the fees or before filing the execution petition, as he had already paid
What is that amount?
the amount, that is actually 5 lakhs.
Who has to tell the court that? How will the court understand that you have paid 5 lakhs?
Then I have also produced the bank statement, my lord,
No,
to that
what-
extent.
What is the purpose of filing the objections? That something will be in the air and court will assume something. Then please come to the order. Come to the order. Read from the reasoning part.
From going through the order sheet in MC number 1539 of 2021 and memorandum of settlement under section 89 of Code of Civil Procedure 1908, rules 24 and 25, Karnataka Civil Procedure mediation rules arrived in MC number 1539 of 2021. It is clear that the joint petition was filed by the petitioners, that is present decree holder and judgment debtor under 13B of Hindu Marriage Act. Accordingly, the marriage of decree holder and judgment debtor was dissolved. As per the clause 4 of the memorandum of settlement, the judgment debtor is agreed to bear full education, college fees, tuition fees, and bus fees, etc., until the child completes his education as per memorandum of settlement. A part of decree reads as under. The first petitioner has agreed to bear full education, school, college fees, tuition fees, and bus fees, etc., until the child completes his education. The second petitioner has agreed to keep him informed in advance about all fees as and when becomes due and payable in advance, so that the first petitioner makes the payment in time, either direct or to the concerned authority, or may reimburse same to the second petitioner. From going through the above said terms agreed between the parties, it is clear that the first petitioner husband, that is judgment debtor, has agreed to bear full education expenses, that is school fees, tuition fee, bus fees, until the child completes his education. The duty casted on the second petitioner wife, that is decree holder, is to keep him informed in advance about all the fees as and when it becomes
Yes,
due.
I've read the order. Yes. What
So
are you
this is the thing. My lord, the very first thing is she has not informed me, and now the order has been issued to attach the property. That's one thing. I am ready to. After informing in the school. Now I am paying regularly. Only thing is the backdated payment, which I have already paid for her 5 lakhs during the pendency of the suit. That's why I take this honorable court to the petition what we have filed.
I've seen that.
Adralli,
And also, court
she
has,
admits that everything has been cleared, there is no due.
paragraph number 9. It is the case of the judgment debtor that during the pendency of the MC petition, he has already paid the amount. Therefore, decree holder is not entitled for the same. For that, he has produced his bank statement dated
Yes.
15/5/2021, wherein amount of rupees 4 lakh is transferred to decree holder. From going through the memorandum of settlement and order sheet, it is clear that MC was disposed of on 18/9/2021 and decree was signed on 22/9/2021. And what is the amount she is seeking now? For which year?
Actually, she has not filed any original document.
I'm asking you, what is the recovery of
Recovery
which year?
amount.
Which year?
Totally 5 lakhs.
Which year? For which academic
22,
year?
23, 21, 22, 22, 23.
With all these kind of vague statements, if you say that I have no, if you're paid 5 lakhs, when the decree, when the memo is filed, that should have contained that for the academic year 2021.
She requested me not to inform anybody and she took the amount.
Then that is between you, which is not enforceable before any court of law.
Yes, my lord, but when I have shown in the, even the bank statement very clearly shows, because
What is executable is the decree. Whatever contains in the decree, that is executable. What has happened prior to the decree was not part of the decree. So any amount of, any submissions on that, or that she didn't, she informed you not to tell anyone, all those things this court can't consider.
I have very clearly told you even in the objections, my lord, about
You didn't
those
tell
things.
anything in the objections.
And
You don't even
the
tell what is the
document
amount
will-
also.
The document only speaks very clearly.
Which document?
The statement what I have
That
filed,
statement is much prior to the judgment and decree.
judgment and decree, but that is between, after filing the petition and after, before
If that
judgment.
is the case, your memorandum of settlement would have contained that for the academic
Because
year, I've
I
already
didn't want
paid.
to hurt her, even in the last stage, I did not want to hurt her. I believed her. Ashte.
Please continue with that same feelings. Please come. Agreed with orders passed in execution number 31 of 2024.
The bank statement very
Dated
clearly
16
says.
10 20. What is this date of the order?
Date of the order is 9, 9/9/2024.
What are you doing till now?
Till now, I didn't get the order sheet earlier. And
Because there is no limitation to file a writ petition, that doesn't mean that order will be questioned after 1 year.
no, because
Order dated 16 10 2024. Whereby the court had rejected the objections of the judgment debtor and has allowed the petition that how is it an interlocutory application?
it's
It's a final order. There is nothing in IA. It's not an order on IA. Main execution itself is disposed of.
no, it's my lord, it's actually on the memo what I have filed on that and on
So
objections.
what is ultimately what is the order? Order is that the execution is allowed. Execution petition itself is allowed. Please come. What did you? Allowed the petition, allowed the execution petition and directed the decree holder, directed the judgment debtor and held that the decree holder is entitled for the educational expenses paid by her towards the educational expenses of the child for the academic year 2022-2023
One
and
submission,
and 2023-2024 respectively, in accordance with the receipts produced by her.
One
the
submission.
parties are referred to as wife and husband.
But all it was the final order. They would have not given the date, further date.
What date they have given? They have not given any date.
Yes, my lord. 1610 ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
No,
Still
court
now it
said-
is pending.
No,
Still
it
now
said-
it is pending.
No, for payment by 16/10/2024. If you don't, the court will do what the court has to do.
Till today it's pending.
Till the execution is completed, it would be pending. The parties are referred to as wife and husband. Both the parties, the petition before this court is the husband who is the judgment debtor. They have filed both the parties have entered into a compromise in MC number 1539 of 2021, and they have filed a compromise petition. And as per the said compromise, the husband has agreed to bear full educational expenses until the child completes his education. And the wife has agreed to keep him informed in advance about all fees and when becomes due and payable in advance, so that the husband makes the payment in time, either direct to the concerned authority or reimburse the same to the wife. Then the wife had filed the execution number 31 of 2024 for recovery of educational expenses of the decree holder and judgment debtor for the academic years 2022-23 and 2023-24. For that, the husband has filed a memo of objections stating that the receipts that are filed by the wife, that the execution is not maintainable. The decree holder has not filed any supporting documents to show the educational and bus expenses, receipts, and claiming it to whims and fancies. She has not intimated to the judgment debtor before paying the fees or before filing the execution petition, as he has already paid the amount to the decree holder during the pendency of the MC at the request of the decree holder. The court had considered the objection, and court has held that as per the said clause in the compromise decree, the decree holder, the husband judgment debtor is liable to pay the school fees. In support of her contention, she has placed the documents before the court. The second contention of the husband is that, basing on the bank statements, he has paid the money to the wife. The court has observed that the bank statement is dated 15/5/2021, wherein an amount of rupees 4 lakhs is transferred to the decree holder. And the memorandum of settlement, in the light of the memorandum of settlement, the MC was disposed of on 18/9/2021, and decree was signed on 22/9/2021. And there is no reference regarding adjustment of rupees 4 lakhs transferred to the account of the decree holder towards educational expenses. In the absence of such term in the memorandum of settlement, or which is part of the decree, the judgment debtor cannot claim that during the pendency of the MC petition, as per the request of the decree holder, he has paid 4 lakhs towards the educational expenses of the child. And it's not the case of the judgment debtor that after passing of the decree, he has paid the educational expenses of the child, and accordingly his objections are rejected and has directed him to pay the amount. Then counsel appearing for the judgment debtor husband, public husband, has reiterated the grounds which are taken before the court, and it is submitted that he has not, that particular aspect of payment of amount was not part of the memorandum of understanding, as the wife insisted that he should not inform anybody about the payment of 4 lakhs to him, 4 lakhs to her. As such, he has not informed, and it is not part of the memorandum of settlement between the parties. It is submitted that the receipts that are filed are not, cannot be considered, and they are not the original receipts. It is submitted that as he is continuously paying, continuously paying the amounts. And as he has already paid in the year 2021, there is no, the execution is not maintainable. Next para, having heard the counsel for the petitioner, this court has perused the entire material on record. The decree was passed on 22/9/2021. According to the husband, he has paid an amount of rupees 15 on 15/5/2021. The present execution is for the year, for the academic years 2022-23 and 2023-24. In that case, the submission that the amount that is paid in the year 21 has to be considered even for these years is not that contention that cannot be considered, and the submission of the land counsel for the petitioner has no force. As per the judgment and decree, there is no mention about the earlier amount paid or about the 20, as that amount has to be adjusted to the further years. Whatever is the agreement between the parties which do not form part of the decree, which is executable, it's not for the court to consider the same. The family court had rightly considered all the contention, all the objections that are raised on behalf of the petitioner and rightly dismissed the petition. The date of order is not 20.
She has not filed the original documents, my lord.
9 something is there, 9/9/24.
9/9/2024.
Yes, dismissed. Yes, next.
For the petitioner lordships in this matter.
Oh, why the memos are being moved? All the fresh matters will be listed before the court. Why the memos are moved? That's a direction by the Chief Justice, and that's what they list generally before this court. So why all of you are burdening the court with the memos? You're making me go through all the memos, which will generally come.
Please.
Immediately once their court officer tell all the advocates for the fresh matters not to move any more memos, and don't take it. Don't take it. Don't take fresh matter memos because they will come once the objections are complied with. So now everybody is giving 100 memos and I have to read all that. This matter anyway would have come today. Yes. What is the order impugned?
Impugned order at page number 15, my lordships. Reasoning at 15 and 16, my lordships. It is enhancement of rupees 25,000 to be
Filed
applied
by the petitioner is partly allowed. 12,000 per month.
Please. Respondent's salary is about 1,70,000.
We are seeking enhancement.
Please.
Oh, all the more no urgency for this case. The petitioner shall take out answerments on the counsel appearing to the respondent before the family court and shall file a memo to that effect. If the memo is filed, once the memo is filed, list this matter.
Much.
Why memo in your case also?
Today matter is posted before the family court for argument. That's why I moved the memo, my lord. My lord, at page number 22.
When is the order passed?
My lord, order was passed on 4th October 2025.
Court?
October 2025.
Then what are you doing till from there?
My lord, I have to get the certified copies and these people will not bring complete copies. I have to collect the agent and agent copies.
No, there's not such a big, so many copies.
My
One
lord,
is one order and
that's
all
how-
other documents are with you.
My lord, that is how the client reacts, my lord.
No, that's why we every day.
First,
this
you will bring
memos,
only with the one copy.
It will come tomorrow. What is the big deal?
My
Yes.
lord, yes. Now onwards, we will not move for the fresh matter.
Yes.
My lord, at page number 22. Yes. My lord, page number 22, my lord.
Page number 22 is an order in RPFC.
Yes, para number 4. Maintains,
Let me understand what is the impugned order. Where is it?
my lord, that's why, my lord, the maintenance petition filed by the respondent was earlier dismissed, holding that the relationship of the daughter with the petitioner has not been proved. Thereafter, my
You
lord,
set aside the order dated 4/10/2025.
yes.
Where is the order dated 4/10/2025?
4/10/2025 is at page number, annexure G, page 48, my lord. My lord, in originals, my lord, the dismiss, yeah, just I will make out 2 points, my lord.
Oh,
Yes,
but
I
show me the
understand.
impugned order.
Yes, at page number 48, my lord, annexure G.
Please read what is the order, what is the operative
My
portion
lord,
of the
operative
order.
portion of the order is page number 61. My lord, we have.
Dated
Yes.
16/7/2025.
Yes, memo is at
Filed by
page.
the respondent, praying order to keep the petition in abeyance
Yes.
till disposal of criminal miscellaneous number filed here by him on the file of this court is rejected.
Yes, my lord,
So-
we have filed a memo for the reason that earlier maintenance petition was dismissed. RPFC has been allowed by this honorable court, and this honorable court has passed an order at page number 27, my lord. If the paternity of the child is not proved, then we are at liberty to file page number 28, para number 5. The respondent succeeds in proving that petition number 2 is not his daughter. He is at liberty to file an application for modification of the order. My lord, thereafter we got a DNA report at annexure D, page number 28. My lord will get at page number 29, the last reason portion, second item. Second item, my lord. I think my lord got
On
it.
whose request it has come?
My lord, in the original suit, on our request, in the original suit, when the suit for partition is filed by the second respondent, it was referred to DNA. And DNA report we have received at page number 29, my lord, para number 2. Last reasoning para, second item. In the DNA profile of Pallavi KR, respondent number 2, daughter of Rajshekhar petitioner, sample blood sent in item number so and so are not matching with that of the so and so in the DNA profile result of Rajshekhar KB, son of Basaraju, sample blood sent to item number 1 does not pertain to me. Item number 2 relates to me. So in view of the same, my lord, I have filed a petition for modification of the interim order under section 127 CRPC.
No, but you said something like abeyance.
My lord, subsequently I filed a criminal miscellaneous 53 of 2025 for modification. This recovery proceeding, in this recovery proceedings, I have filed a memo to keep this in abeyance till disposal of my petition filed for modification of the order under section 127 of CRPC. That memo has been rejected by the family court. The rejection of the memo has been challenged in this writ petition. This is execution process. CMS number 67 of 24 is execution proceedings. And CMS number 53 of 2025 is a petition filed for modification under section 127.
Come to paragraph number 13.
Yes. No doubt petitioner have not denied the DNA report obtained in said OS number 36 of 2013 pending on the file of the third edition senior civil judge Tumko. But the contention of the petition is that the said report is not yet considered and it is under still consideration. During the course of argument, learned counsel for the respondent concedes the fact that DNA report obtained in the said OS 36 of 2023 is still pending for consideration and the petitioners have sought to summon the expert for cross-examination. So it is clear that DNA report obtained in OS number 36 pertaining to the paternity of the petition number 2 is not at all considered by the concerned court and still it is under consideration. No doubt the Honorable Supreme Court of India in the decision cited above by the learned counsel for the respondent here that result of a genuine DNA test is said to be scientifically accurate and presumption under section 112 of the Evidence Act will not be available. With due respect to the above cited decision, here is a case admittedly the DNA test report obtained in OS number 36 of 2023 is not yet considered and it is still under consideration by the concerned court. The petition in OS number 36 of 2013 to question the genuineness of the said report sought to summon the expert for cross-examination. Therefore, unless the court is...
Please come to 14.
Yes. As noticed above, the Honorable High Court of Karnataka in Bangalore in WP number while passing interim order made an observation that so far as the maintenance of the wife is concerned, that is the petition number 1 is not disturbed. And with respect to maintenance amount of petition number 2 is concerned, directed the respondent shall continue to deposit the maintenance amount. But the respondent has not completed the said order of the...
Pausing here.
In view of the order passed in...
No, pausing here. Why you did not comply with the order?
My lord, my lord, the fact that the DNA report, she herself is not a,
Till that is adjudicated by the court.
my lord, there is a 4 weeks time, my lord. In WP number 23-245, 21st, 4 weeks time granted as not.
What about RPFC?
My lord,
That order is in RPFC.
RPFC, but this writ petition, there is a time, 4 weeks time has not yet been
What will
completed.
happen to this RPFC order?
RPFC, it reached finality. RPFC reached finality.
Then. what
Then,
is
my
the
lord,
order?
liberty has been given
Order
to.
of family court is modified to the extent of awarding maintenance of rupees 5,000 per month.
Yes.
To petition number 1 and 2.
Yes.
Directed to main per month, so and so, till she, so and
So and so. Then liberty was given to file a petition for modification.
Continue to do.
We have filed the modification. Filed the petition for
This
modification.
order is when?
My lord,
This order is when?
this
This
order.
order is passed on 13th February 2024.
Yes, please.
When is the report, DNA report?
My lord, the DNA report was submitted on 19/4, but it was available to the petitioner only in the recent last month.
That's what, which month?
Please,
That
my
is in the month of September.
Yes.
So what are you doing from 13th February 2024 till September 2024?
My lord, we are under the, we are having the knowledge that it was
You have to
submitted.
comply with the order of the
But
court.
copy was not furnished to me. That was the problem. Yes.
That's fine.
Sir, we
Then
have
you
the
to-
knowledge of furnishing the
You
report.
have to comply with the order of the court, whatever it is.
My lord, even
It's
the,
adjudicated.
my lord, even the family court has held that. Even in the birth certificate also, it is not a genuine document at page number 22. These are all the several circumstances, my lord, suspicious circumstances.
You can't
My lord,
take
if it is
advantage
paid,
of
my lord, I
the-
cannot recover the amount once.
You can't take advantage of the order and also want to, say that, that order I will not follow.
And the secondly, my lord, the petitioner is getting only 6,300
Different
salary.
aspect. That's a different aspect. No, we are not on that.
So there is no source of income also to pay, my lord. The entire family property
So
has
did
been
you
attacked.
question this RPFC by filing further appeal?
No, my lord.
And then,
It has reached finality.
so please, whatever the grounds that are all available, that we will know. You can't.
My lord, if I
violating the
succeed,
orders of the
my lord,
court.
if I succeed in 127, then I cannot recover the amount. So the liberty has been given to file 127. I have filed 127,
When did you file 127?
my lord, in the year 2025.
Then,
Immediately after I got the,
till that is adjudicated by the court, are you not supposed to comply with the orders of the
Lord,
court?
immediately I got
If
the,
the order of the court is not complied, why can't they file an execution petition? What is the purpose of passing all these orders?
my lord, on 19/4/24 itself report was submitted, but it is not available to me. We know that the report was submitted, but it was not available to me. Immediately after I got the copy, I have filed the petition under section 127. Till then, I cannot file until I got the copy.
Until the orders are passed, you can't afford to not to comply with the order of the court.
My lord, there's a different circumstances, my lord. It's not a like that of when she is not only a daughter of the petitioner, my lord. Several prima facie materials were placed. Even trial court has come to conclusion, even birth certificate does not prove that she is a daughter.
In the OS, whether that was considered by the court,
My lord, the Honorable
adjudic-
Supreme Court has
any-
said that filing of the DNA report itself is a substantial material and presumption under section 112 of the Evidence Act.
Whatever it comes, there should be an adjudication on that.
My lord,
Just like that, basing on a report that is placed in some other court, in some other case, where the court has not determined whether the legality or otherwise of it. How can we consider, how can this court, the court which is dealing with the maintenance?
my lord, between the same parties, my lord, in every case, we cannot ask for DNA test.
No, between the same parties, that has to be decided. Every document that is filed before the court, it is not a gospel truth. It has to, there is a procedure to,
Yes.
adduce
My lord, in
evidence.
civil
determine-
cases, we know it will take considerable time to decide the issue. So, prima facie report is submitted. Prima facie family court has held that.
Prima facie report is submitted, you are supposed to comply with the order till any adjudication on that. You
And
can't take your own
even my lord, family court also on available material earlier also held that the birth certificate does not give suspicion that she is not a
Ultimately,
daughter.
your RPFC is affirmed.
Yes, I understand, my lord, RPFC, but thereafter in RPFC also liberty has been given to the petitioner.
No, that has to come in such time. Why should everything be stayed?
Okay, now we are not asking for such kept in abeyance till disposal of the.
That's what I'm saying. Staying abeyance means you
My
are
lord,
asking.
if I have complained, my lord, how to recover the amount? if I have completed the amount, there is no reasons for me, I cannot recover the amount. So it will be, so even if you got to
For the last 1 year, you were waiting. You could have done the same thing about a year back.
when the report was not available to me, even I know that report was submitted.
I don't think,
Until report is
report can-
available to me, I cannot file a petition
Please
for.
come. The presented petition is filed. Agreed with orders passed in I number on a memo dated 16/7/2025. In C miscellaneous number 67 of 2024, dated 4th October 2025. By order impugned, the memo dated 16/7/2025 filed by the husband to keep the petition in abeyance till disposal of criminal miscellaneous number 53 of 2025 filed by him is rejected. The facts of the case are the wife had filed a criminal miscellaneous number 378 of 2013 seeking maintenance, and the same was dismissed on 28/2016. Then the wife had preferred RPSC number 192 of 2016 before this court, and the same was allowed on 13/2/2024, directing the husband to pay monthly maintenance of rupees 5,000 to the petitioner number 1 therein till her lifetime or till she remarries. Petition is to the wife until she remarries, and 5,000 to the daughter or son? Daughter till her marriage. And also has further observed that if the husband succeeds in proving that the daughter is not the biological father, then he is at liberty to file application for modification of the order. It is between the parties, OS number 36 of 2013 is filed on the file of the third additional senior civil judge at Tumkur, wherein the wife and the daughter are impleted, and the petitioner is defendant number 5, and that they are impleted as defendants 8 and 10. And during the pendency of the said suit, an application is filed for DNA test, and that was ordered. And as per the DNA test, he is not the biological father. Hence, as per the orders passed in RPFC number 192 of 2016, dated 13/2/2024, he has filed criminal miscellaneous 53 of 2025 and a 121 CRPC in the year a month before in the month of September. And when the wife has filed the execution, the husband has filed this memo seeking direction to keep the pending or keep the proceedings in this case in abeyance till the other matter, till his modification petition is considered by the court. That came to be dismissed by order impugned, observing that the DNA test that is submitted in the other suit, it has not attained finality. There is no finding in that regard. In those circumstances, this court, when the court cannot keep the recovery proceedings in abeyance. Next, Parliament counsel appearing for the petitioner submits that when the DNA test, which is a scientific report, says that he is not the biological father, question of paying the maintenance does not arise. It is submitted that if he pays the amount, it becomes difficult for him to recover the amount. The order is passed in the RPF, it's difficult for him. Next, having heard, and the court ought to have kept the matter in abeyance. Next, having heard the petition so and so. The order is passed in RPFC number 192 of 2016 on 13/2/2024. And the petition is filed seeking to modify the order on a DNA test in the month of September. Right from 13 to 2024 till September 2025, the petitioner has kept quiet. When the kept quiet, and when the EP is, and they have filed the EP, the petitioner, and the EP is for both the wife and daughter,
Wife and daughter.
then wife, there is no problem. Why you didn't pay?
Wife also, mother, she's living
No,
in
no.
adultery, living in adultery.
That is not the liberty that is given to you. The and convenient, and now conveniently, this application is filed, this memo is filed.
on 16/3/2023. The only reason for recording this order by the Honorable Court was that, my lord, if a lordship sees on 1/12/2022, they come with an order from this Honorable High Court seeking a specific direction to close the matter within 6 months of time limit. In view of the same, my lords, the court made up its mind saying that since there is a time has been fixed by the Honorable High Court, the matter wanted to be get over by 6 months of it, my lords.
I'm sorry, my lords, I'm sorry. This is thorough misleading. May I draw? Please. Please.
Please.
Sorry, my lords.
Why you are going back on this submission?
No, certainly not. All that I'm aggrieved is this, my lords. Let there be a uniformity, because what has happened, the Honorable Family Court, when they adjudicated upon my IA number 516.
No adjudication required. No, all this will be required provided all this have to be proved.
Please.
So both of you say, whatever are the grounds that are raised.
Certainly.
There will not be any finding on that. The
Please.
decree of divorce will be granted.
Certainly.
Now what left is your alimony part.
Certainly.
So that is better evidence.
Correct, my lords.
What's the difficulty now?
I'm okay with it. I'm completely agreeable. What happens is, my lords, here upon their memo, what the court said is we will consider the entire case upon its merits. Whereas when I had preferred an application under 516, IA number 516, they reject those two applications, telling that there is an order dated 16/3/2023. Therefore, we need not have to go into the contentions of grounds.
Please, my lords, your lordship may kindly see the memo. It is at page number, my lords, 81, annexure H. May permit me to read. The counsel for appearing for the respondent, who is the petitioner here, my lords, was thorough with the case, completely led the evidence. Please, may I read, my lords. It is submitted that the petitioner has filed the present petition under section 13, clause 1, clause A of the against the respondent for dissolution of his marriage, and also contended that the respondent has committed adultery against him during their marital life. The respondent has also filed a counterclaim in the present petition. It is submitted that on 16/3/2023, this Honorable Court, after conciliation with the parties, and the parties have expressed that both have sought relief for dissolution of their marriage. Subsequently, this Honorable Court passed an order dated 16/3/2023 stating that the parties to lead their evidence in respect of the maintenance, and petitioner is here directed to lead evidence forthwith. It is submitted that since the respondent has filed counterclaim in the present petition and has sought for permanent alimony amounting to crores, and in view of the same, the petitioner has led his evidence and has cross-examined the respondent DW1 in detail pertaining to cruelty and adultery committed against him. In view of the same, the respondent is not entitled for any relief as prayed in her counterclaim, hence this memo. Wherefore, to take this on record, my submission was that, my lords, my petition was under the grounds of cruelty, that's not in dispute. The only thing is that if I am unable to prove my cruelty for a moment, my lord, I have to prove my cruelty based on the conduct of the respondent who has committed adultery against me. If I fail to prove cruelty, since there is a counterclaim and 50 crores of rupees counterclaim has been sought for. So such being the case, my lord, what I want, the submission was made by filing of the memo. This, my lords, after concluding the arguments of the petitioner, this was brought to the notice of the Honorable Court by the counsel for the respondent. After concluding the arguments of the respondent, if lordship sees the order sheet, I concluded my arguments on 1/10/2024. When the matter was posted for the arguments of the respondent counsel argued for 2 days. On the third day, he brought to the notice of the Honorable Court that there is an order dated 16/3/2023 where the parties are given a consent to lead their evidence. Certainly, my lords, if I have led my evidence, because if I fail in my petition, my lords, there is a counterclaim for cross of alimony, my lords. So if I prove my case through that the respondent has committed adultery against the husband, for the said reason, my lords, and admittedly both have been exclusively been cross-examined. Documents have been marked. I have marked around 30 documents. He has marked around 40 to 50 documents. Based on that, I have marked documents for proving cruelty. And that was before, my lord. This is on 16/3/2023. What had happened? It's not about consent, my lord. We said that yes, quantum of maintenance has to be decided based on the merits of the case. That was a consent, my lords. If I prove my case, if the counterclaim of the respondent wife is dismissed, I don't have to pay any alimony to the respondent wife. If I prove my case that she has committed a cruelty on me by way of adultery, since there was no direct evidence with me, my lords, I was not able to invoke adultery provision in my divorce petition. I invoked the provisions of cruelty, so that, and in the documents have been partly been admitted with regard to the contents of the case, but documents has not been admitted properly. I had a document to show that she had committed adultery where she consulted a doctor, where she took the prescriptions for postponing of the thing, my lords. At that point of time, that original document was snatched away by me. I had only the Xerox copies. I had placed it along with my petition. So I wanted to prove my case on cruelty that she has committed adultery on me. If I had a direct evidence on me, even that document was not subject to objections. Such being the no. Please, I made an application for that also, summoning of the document. No, there is no. My lords, in this what happened, my lords, at the time of my evidence, I filed an application seeking to summoning of the document which is under the custody of the respondent.
No, because you have invited all this, let set aside this order. Let the court go as in the usual, whatever manner of the issues are to be framed, or how the issues are to be dealt with.
No, issues are not framed, my lords. It was directly posted for the petition evidence. Based on that, evidence was like.
Can the court proceed like that?
No, that is the which has been conducted, my lords. In generally in the family court matters, my lords, in MC matters, generally they don't post the matter. No, not only in this matter, my lords. In all the matters, my lords, it will be not posted for any issues, my lords. Once the objections is filed, my lords, if there is any failure in the conciliation between. Please.
No, my lords, in fact, in that context, my lords, I need to bring to this honorable court's knowledge two aspects. One is he has not filed divorce on the grounds of adultery, first aspect. Second aspect, my lords, I have filed a counterclaim. There's no objections that is filed for the counterclaim as well. There is closed way back in 2022 itself, the stage. So that order has not been challenged by the husband. He is not, again, that order has attained finality basically.
What order?
In terms of like him not filing objections to the counterclaim. So wife files a counterclaim, seeks for divorce.
So let's start from that your counterclaim and let the court take next 4 years.
If that is the case, then I had to admit to file objections to the counterclaim. Then, if that is the case, my lord, if that's the case,
from that stage of counterclaim and we will fix the time frame for 4 years. Let it go on for 4 years.
Let's make one submission. When it is evident that the husband has been negligent.
Both of you for your file, you accept before the court. Don't deal with the. We are both ready for divorce. Only deal with the alimony. Then there is an order from the High Court to deal with the case in 6 months. Because the court said within 6 months the matter has to be disposed of. With a shortcut method, the court proceeds. Now at the fact and he files a memo and court says whatever evidence is available, I'll consider it and pass orders. What is this?
No, it is my duty to bring
after this,
my lord's attention one other aspect. As on the date that 16/3/2023, there was no order by the High Court. As on 16/3/2023 order, which basically said that both parties are consenting for divorce, there's no direction by the High Court. The High Court, in fact, my lords, passes a direction only on 8th of November.
I'll set aside this order.
I make one submission, my lord. If that is the case, my lord, what had happened, my lords? They completed their arguments, my lords. My lordship may kindly appreciate the thing, my lords. They completed their arguments. The matter was posted for the judgment. This petition is filed. That is my specific contention in my objection. Lordship may kindly see my objection statement for a moment, my lords. It's not that they have immediately come to the court.
My lords,
they completed their arguments. We support the filing the written arguments. When the matter was posted for the judgment, they have filed this petition. My lordship may kindly see, my lords.
So now both the counsels and the judge, you have evolved a procedure how to conduct a case now in this.
That's what it is. And I'm sorry, my lords. That was not my intention, my lords. I'm
what you people wanted, what the court wanted. Now the court will go and accordingly we'll let it go.
No, my humble submission.
There is a procedure.
My respectful submission to this honorable court, my lord, is that, my lords, this.
Where are the docket proceedings? Let's see.
Which, my lords?
The orders. What has happened?
Please, my lords.
Let's see.
The entire order sheet has not been produced by me.
Wasting. This is nothing but wasting court's time.
We should kindly for a moment
impose costs on both of you for being parties to the 16/3/2023 order.
May I make one submission, my lords? Your lordship may kindly come to para 10 of my statement of objections, my lords.
Where is it?
Page number 7, my lords. In WP number 6286. Para 10 of my statement of objections, my lords.
Yes.
The petitioner herein, who is the respondent in MC.
Para number?
10, my lords. Page 7.
Which petition you are referring to?
WP 6286 of 25.
Yes.
Please.
Yes.
The petitioner herein, who is the respondent MC, in order to
Running pages,
7, my lords.
running page,
Please, my lords. Objections running page. My objections.
not objections running page. I have to see where are the objections, in which page number?
No, my contention in the present petition is what I'm trying to bring it to honorable court, my lords. For a moment.
Oh, you're referring to WP 6286.
Please, my lords. I filed
Page
objection.
number.
I filed objections, my lords. I have filed objections on 18/6/2025, my lords.
Yes,
Please, para 10, my lords.
yes.
The petitioner herein, who is the respondent MC, in order to controvert the contention raised by the respondent herein, has got documents marked as exhibit R1 to R46. It is further submitted that if all the documents marked by the petitioner are harmoniously scrutinized, it can be concluded that the petitioner was.
The counsel of the petitioner shall place before this court the entire order sheet pertaining to the MC. Then I'll decide.
Please, my lords.
But I'm telling you, in this case, I'm going to impose exemplary cause on whoever is
May make one.
responsible for all this.
May make one submission.
And also again litigating on that.
Certainly, may make one
Get
submission.
it, please get that.
Let's
This is matter on 28th.
Oblige, my lords.
Very well. Interim order, my lords, may kindly be extended.
What was the interim order?
Interim order not to pass the judgment, my lords.
order?
In fact, it was posted for judgment, passing of
I
judgment.
pass this order.
No, no.
No, my lords. Predecessor had already passed. Stay of all further proceedings had been.
So you're enjoying it from 3/3/2025.
It's certainly not that. I have been
Matter on
prejudiced.
Tuesday, as parted, we'll dispose it off on that day.
Please.
List number 2, for orders matter, serial number 1. List number 2, serial number 1.
For the respondent bank.
Menendez.
What are these office objections?
Lord.
2024 matter, we still see it for non-compliance of office objection.
Respondent has filed an vacating IA, my lord, and also objections
No,
raised.
what is this non-compliance of office objection? That is council submission, your submission.
Please, my lord.
What is that? At scrutiny stage. And why are we hearing the matters without even complying with the office objections? And you have an interim order in this.
We are ready to close on the account itself, my lord.
We will not, 2024 matter, for no reason we should wait till now. Yes, what is the impugned order?
Impugned order, my lord.
They challenge the e-auction, my lord.
E-auction, my lord.
They have complied the interim order, but not clear the whole loan.
Why should we interfere with the e-auction notice? What is the reason?
My humble submission, my lord, he is ready to close on the entire amount as on the dues.
Who
as
is
on-
stopping them?
My lord, he has,
What is the outstanding amount?
My lord, 37 lakhs, my lord.
What is paid by the interim order?
That,
8 lakhs, my lord.
Why should we show this indulgence?
Only 3 days accommodation, it may have taken on Thursday, my lord.
About 3 days, you filed this writ petition in 2024.
Yes.
When is the interim order granted?
Interim order is, my lord, on
It is not as a routine matter of course that we grant orders and 14/3/2024. 1.5 year.
I'll only seek only 3 days accommodation, my lord. It may have taken on Monday, my lord.
Why is that yours a special case?
I'm
That
not-
you take 37 lakhs and 8 lakhs you pay in the month of March 2024 and still we wait for you to pay the amount. And why are we interfering in this?
Since I have OTS applied for the bank, my lord, that bank has not approached till today, my lord, for reduction of some amount in the interest rate. That was the only apprehension of the petitioner, my lord.
Take it up in 2027.
My lord, my humble submission, it may have taken on 3 days accommodation.
I'm
Taken on.
saying we'll take it up in 2027.
No, I'm sorry, my
So
lord.
that
That is-
by the time you will be negotiating.
That
they
is
will
not
be
the, that is not the, that is not the case, my
That
lord.
goes on.
I apologize for that, my lord. That is not the case, my lord. It may have taken on Thursday, my lord. He's ready to close on the account, my lord.
Matter on Thursday. By the time, whatever, whether any, whatever is even if whether the petitioner pays the amount, if the petitioner by the time pays the entire amount due to the bank, if he doesn't pay, we'll pass orders, list this matter as parted, and the office objections shall be complied, or
Yes,
else the petition shall stand dismissed. within when is the date that I have given? 30/10. By 28th, the office objection shall be complied with, or else the petition shall stand dismissed.
Please, ma'am.
Yes.
Cell number 2.
On submission, my lord, since my OTS is pending for the bank, maybe consider that whether it's a reject or.
Already you had, the
Petition
court has
itself is
given you a
not
long
maintainable.
rope. Yes.
I have approached the bank many times, my lord, there are no response from them. That is the only apprehension of the petitioner,
That's
my
not
lord.
the concern of the court at all. Yes.
Cell number 2, Sri Rajashekar, for petitioner.
Yes. What is this council submission?
Non-parties, some of the respondents who are not the parties is made notes for which a council submission is made.
The cost title at so and so is incomplete. In view of the urgency in this matter, same may be accepted. What is this council submission?
It's the cost title as it stands in the application appears to be complete, Sam. Because that's what I was instructed.
No, it says incomplete in view of the urgency, and the registry accepts this submission. If
No,
there is
the registry is
urgency,
placed it, but page 68, if your lordships were to kindly take page 68, the cost title is complete. There are 9 parties in all, including the
Please.
applicant, 5 plus 4, 9.
give it to the senior counsel. Please read it. What is this council submission? And they
These
place
are
it
not
before
the
the
kind
court.
of
Very unfortunate. Please read it. Please read that.
Should cover your lordships. Also, I just asked them to read because as I could see, Milords, from this,
No.
cost title is in
No,
fact
strange,
complete.
here it is.
No, that's
They
very
write such a
absurd.
submission,
Very, very
and
absurd.
the registry place it before the court.
I know, that's, your lordship should not be troubled on this. But what I have seen, Milords, from the order sheet is that the cost title is in fact complete. Kindly have a look
There
at
is a cost title before the court.
page 68. Annexure C starts at page 67 at page 68. There are totally 9 parties. Applicant is State Bank and there are 8 respondents. And before your lordships, there are 4 petitioners and 5 respondents. All of them are parties. I don't know, there's some with reference to annexure C. Lords, I seek your lordships pardon because not the kind of matters which should come before your lordships on such things. But what I found, my lords, when I was briefed is the entire case of the bank is dependent on a tripartite agreement. Lords, we are the owners of the property. We execute a joint development
But
agreement.
what we
with the
do is,
developer.
let them comply with the office objection, then we will hear it. Others will
Lordships,
not. This is matter on Monday. On Tuesday, provided the office objections are complied with.
Please.
Cell number.
That office objection number 4, my lords, requires to be overruled because the
What
cost
is that?
title is complete. The last of the objection. That cost title is complete. The other objections, I'll ask them to comply with it.
Nida.
Good.
Names of R2 to R5.
Yes.
At cost title not found. At annexure F.
Annexure F. Annexure
And
C.
made party to this writ petition to be clarified.
Yes, if your lordships were to see
Please
annexure
do
F.
that. What is, let's look at annexure F is?
Lords, that is the, if your lordships were to take page 160, it's the order, my lords.
No, what is the order impugned?
Lords, I'll just, lords, the original cost title in the OA filed. They are all those persons who are the parties is reflected in the cost title in the writ petition. When an application was filed in the OA by 4 applicants and making only State Bank of India as a respondent. Kindly have a look at page 160.
No, whatever is the impugned order, that should be as it is carried to the, shall be
Lords,
reflected in the.
it is the cost title of the original proceedings which is carried forward.
You are questioning an order. That cost title should be reflected.
Even that is reflected, even State Bank
So
of
that's
India.
why we look at it. Like
Kindly have a look at page 160, my lords.
160. This is the impugned order now.
This is the impugned order. 1 to 4 are the petitioners before your lordships. Applicants 1 to 4. And respondent number 1 in the risk petition is the respondent in the cost at page 160.
That is sufficient for this application. Do it. Because we don't require all the people in OA. You are only concerned with this application. So let as per this annexure F.
Lordships may I record my statement that I may be permitted to delete them from the array of parties in accordance with annexure F.
The petitioner shall comply with the office objection. Objection with regard to array of parties. And as R2 to R5 are not the parties
in the order impugned.
The same shall be. The
Be
petitioner
permitted
is
to be carried
permitted
out,
to
otherwise
carry out the amendment.
Please.
And list this matter on Tuesday.
Lordships, so grateful.
Yes.
Cell number 3, Naveed Ahmed.
Yes.
Lord, the office objection is not making the co-borrowers as parties to the proceedings, Lord. Lords, I have made the borrower as a party. Lords, kindly see the petition, Lord.
Arising out of which proceedings?
Lord, 13 form, Lords.
Let's see that 13 for.
Lords, I am a tenant, my Lords. I am a registered lessee. Lords, this lease is executed prior to the Lords, the loan. Lords, my lease was, Lords, in September 2021. Lords, loan was granted in Lords, April 2022.
So all the borrowers to the transaction are parties to this?
Lords, kindly see, Lord, the notice, Lords.
Yes.
At Lords, annexure B, page number 29.
Who appears for the, without hearing the other side, I'll not interfere with this matter.
Lords, let them not, Lords, disposes me, Lords. Only thing, Lords, I'm in possession.
Who appears for this?
Lords, Francis
The
Xavier.
council is appearing.
Francis Xavier, Lords. Francis Xavier.
Write it on a paper.
I will
So
give.
and so is directed to take notice on behalf of the first respondent. This is put in the name of the council, and the council for the petitioner shall serve the copy on the council for the respondent. List this matter on Monday.
Lords, the office objection may be overruled, Lords. I have made my lesser as a party to the proceedings, Lords.
Who are the other? I'm not able to understand.
Just see, Lords, the lesser.
How they come to know that there are some other people?
Lords, the notice, in the notice it is mentioned, Lords.
To make them a party also. What is the difficulty?
Lords, kindly see, Lord, the lease agreement. Just see, Lord, the page number 9, Lord.
No, you are questioning a particular notice. In that, all these details are there. Make them a party. What is the difficulty in that? In making them a party?
Lords, I made my lessers as a party, Lords.
Them also make a party. Office objection.
I don't know who they are, Lords.
What is there in that? Address not known.
Lords, they have mentioned only name, Lords. There is no address.
What you say? So and so. As
Okay,
per that,
Lord,
address
it will not be
known.
served, Lord. Ultimately, Lords, again
Do
I
it,
had to pay process, Lord, it will not be served.
Office objections are overruled.
Obliged.
This is matter on so and so on Tuesday.
Obliged.
Give the papers to them. If papers are served to them prior, then only
I will do it,
I'll hear the matter.
I will do
Yes.
it. Obliged.
Cell number 4. Cell number 4, K.S. Ponnappa for petitioner, M. Ashok Kumar for KV
Lords. Please,
What is
my
this
lords.
office objections, council submission?
My lords, the caveator has been served the soft copy of the writ petition through mail, my lords.
I'm appearing for the respondent bank, my lords.
That's objection.
And the second objection is that Mahalakshmi Enterprises has not been made party. Say, I am the title holder, original title holder of the scheduled property, my lords. I am opposing the sale notice.
The
They
party
don't
to
have
whom
any.
the impugned annexure is issued is not a party to this writ petition.
Yes, my lords. But if you look at the notice, my lords.
Where is the impugned notice?
Impugned notice, annexure A, my lords.
On 4th October, my lords.
1 minute. Annexure A. Mrs. Mahalakshmi Enterprises. Who are you?
My lords, I am the title holder, my lords.
Who is Mahalakshmi Enterprises?
Mahalakshmi Enterprises is my sister's. My sister is the proprietrix of the
So,
company.
is Mahalakshmi Enterprises not a necessary party to this?
My lords, they are not opposing the sales certificate.
Who
my
will
lords.
know? We don't know. You have to make them a party. You have to make them, notice has to go to them.
Because we the
But those issues are not relevant. You are questioning a notice that is issued to Mahalakshmi Enterprises.
But the property is in
Let it be, let it be. You are questioning this, let them be a party to this. You cannot decide who has to be the parties. Yes, the office objections. The office objection with regard to the array of parties is upheld. And the petition shall carry out the necessary amendment.
Can I
within-
make a small
within-
submission in
Within
this?
2 days, this is matter on Wednesday. Yes.
Can I make a small submission, my lords? My lords, this notice has been issued to Mahalakshmi Enterprises, no doubt. He is the guarantor, my lords. And only on the ground that he has already initiated a personal insolvency under IBC, he states that we should not be issuing any sale notice. However, no notice has been issued to us that he has initiated a PIRP. Also, there is no notice issued to us.
Letter complete, and you come up with, you can, in the meantime, you file your objections also. Yes.
Cell number 5, V.S. Jain Krishna.
Appearing for the petitioner, my lord.
What is the objection?
My lord, only one objection, my lord. The prayer was not clear. I have applied the whitener, my lord, even I have rectified. It is matching with my interim prayer also, my lord. That is the only objection, my lord. Page 14 is my prayer, my lord. I've challenged the intimation letter.
Please read what you wrote.
Issue a writ of certiorari.
No.
Please. They were like, it was not legible and not clear. That was the office objection, my lord.
Then what about some D or something you wrote, some?
D series it was mentioned. Then I have made it as D1, D2, D3, my lord. Those are the letters. Those are the letters and invoices, my lord. So series should not be made. It has to be D1, D2, D3.
So why the memo is moved? What is the urgency?
Please, my lords. At annexure A, my lord, page 18.
Sale proceeding has been initiated.
Please, my lords, on 25/10/2025.
Proper notice
Please, my lords.
and for redelivery of the
Vehicles, my lord. My lord, what had happened, my lord?
the bank.
Bank is Sundaram Bank, my lord. Sundaram Finance.
Yes, for Sundaram Finance
Don't know, madam.
Council.
It's an NBFC. We don't have any. It's a Chennai-based head office, my lord. But what had happened, my lord? Without issuing seizure notice, they have seized my vehicles. And even they have not done any due diligence. For a moment, I'll show, even there is an FIR.
Anyhow, they have taken possession.
Yes, my lord.
It has to be redelivered.
Please, my lords.
They have to hear the other side.
Please, my lords. But today they are conducting the auction, my lord. That has to be stayed, my lord.
When they have taken possession,
My lord, they themselves mention on 12/8/2025.
what are you doing from there?
I got the registered acknowledgement due on 18th, my lord. The courts were holiday, my lord. They did not even inform.
Without even hearing the other side, how can whatever you say, that cannot be the only reason for this court
I'll
to
show
pass
my
an order?
annexure, my lord, for a moment. Photographs has been sent by them. They themselves have sent along with the location and the date, my lord. For a moment, annexure F, my lord, page 36.
What are those vehicles?
It's a heavy duty vehicle, commercial vehicles, my lord. With loads they have seized, my lord. Even my load, the contract between third party has been interfered, my lord, by these agencies. And they have even assaulted the drivers to that extent and
That
FIR.
all that we are not going into.
Please, my lords.
Now, how do you, I have, unless I hear this Sundaram Finance, I can't pass any order.
But if the very purpose of filing this writ petition is to
Let it
avoid
go,
this.
what to do? But just like that, this kind of ex parte orders are creating the problems.
No, but I'll serve
Without knowing
immediately.
And you know, all these agencies,
Please, my lords.
whether it's acceptable to you or not, there is a procedure they do follow.
Please, but in this case, they have not followed, my lord. I can demonstrate before my lordships.
But I'll tell you, I'll grant you, and if I grant you an interim order,
Please,
and
ma'am.
provided once the Sundaram Finance appear before the court and they inform the court that you have the notice of any of the proceedings prior to this,
Please, my lords.
you have to file an affidavit before this undertaking before the court that you will be paying 10 lakhs as cost for the suppression, if any.
My lords, as per the notice what I have received, I have.
No, that's what you are not about all that. You say whatever you have stated in the petition. And that you have no knowledge till 18 of any of the proceedings that are initiated in respect of this loan from the bank, and you have only come to know on 18th.
18th.
If those statements If any of those statements are not correct, I will record that.
For a moment, annexure B, my lord. I know, even there was conciliation between us. I'm not denying, my lord. After that, they did not deal. I have paid my EMIs also. It is a pay annexure B for a moment.
Let me read. What did you say? And I'm telling you, I'm going to be very stern and strict on this. And
This
your
notice,
client-
I was brought to know.
Your client is going to pay for this kind of interference by the court without any basis, if it is without any basis. That's why I'll pass over this matter, get instructions from your client, if he is ready for an order of that nature. Yes, pass over. Yes, next.
Please.
Step number 6, hearing on interrupted application. K. Shashikant Prasad.
I am for the respondent in this matter. My lords, they had filed a section 14 petition earlier. That's almost nearing a year. They have not complied. They seek a liberty of this honorable court. They withdraw it. My lords, on suppressing the facts, again they filed the same writ petition and they obtain a stay.
Where is the earlier order?
My lords, I
Where is
filed my
your
objections
petition?
on 12/8. My lordship may come to page number running 5. Page number 5 of my objections.
Yes.
My lord, this is the interim order that was passed in the earlier writ petition.
What is the number of the earlier writ petition?
My lord, 26599 of 2023.
599 of
2023.
That is file questioning.
My lord, the same section 14 order.
Section 14 order is question.
Yes,
What is the
ma'am.
interim order in that?
My lord, to deposit 15% within 3 weeks and the next 15% within 3 weeks.
Stay of the order dated past in so and so.
Yes, ma'am.
Depositing 30% of the
Yes,
amount.
ma'am.
This order was dated 13/12/2023.
Yes, my lord.
Then
My
have
lord.
they deposited any amount?
No, my lord. Page number 6, my lord. That's the final. My lord, on
This
14
order is dated 4th.
November 2024.
So this interim order is pending
Yes, my
from
lord.
13 to 2023 to 4th November 2024.
24. And
then
they
what is
withdraw
the
the writ petition after we filing our objections and seeking for vacating the IA.
This is withdrawn.
Yes, my lord.
Then
Now suppressing the facts
what
of,
is this appeal judgment?
my lord, this is on the
Judgment.
limitation,
Huh?
for the limitation purpose.
Uh,
My lord, they are barred by limitation even otherwise considered.
then leave that. Now please come to the,
My lord, now coming to this writ petition, the same section 14 order has been challenged. And there is not a word about the previous writ petition.
and the interim order is granted in this again.
Yes, my lord. In this they have made a payment, but they have not mentioned about.
Paid payment here, 1,90,000 you have paid.
No, I did not supposed to disclose filing of earlier writ petition, obtaining an interim order, then that writ petition being withdrawn. Why did you withdraw?
I don't know.
You don't know. Because
I'm
we have-
earlier advocate.
He has filed his objections. Have you not has put forth this to your client?
This was withdrawn, my lords, on 4th of November. On 13th of November, they filed this writ petition and obtained a stay.
Filed one Kavita Yan here. Earlier, Kavita Yan has filed.
Kavita and you are not one and the same, but the client is the same. So he has not
He has
properly
not informed.
instructed you.
Yes.
And he has, by all suppression, he has filed this writ petition. We'll dismiss it with cost.
Lordship,
With
it is-
exemplary cost.
It is a education loan here.
So what?
Some
We
concession.
will not, we will not. Nobody is permitted to play with the process of the court. And see how dare he is, your client, without even informing you what has earlier happened, transpired, and filing a writ 1.5 year, almost 1.5 year, you have enjoyed the stay. And you withdraw. Again, you file a writ petition and obtain an interim order.
She has obtained for education purpose.
Let them do for anything, but one should be fair. When is this order passed?
14/11/24.
What is the amount?
15% of the.
Council.
My
What's
lord,
the amount?
as the outstanding as on 22 was 18 lakh change, my lord. As on today, I'm not aware.
As on 22?
My lord, 12/10/2022. But my lord, I've produced the statement of account. My lord, the outstanding is 10,24,981 as on 28th of July. That's at page
Did you
25.
file your, any objections or your, to this, the vacate stay? Vacate petition?
No, it is not.
When was it filed?
No, sir, I have filed it on 12th of August 2025.
Yes, stated everything. There is alternative,
It's not about it, about the suppression of fact.
nothing else.
Hmm? Not that they are small children, 30 years old, 53 years old. Please come. The present writ petition is filed. Seeking the following prayer. The case of the writ petitioner is that they approached the respondent bank for the educational loan, and as per the letter dated 28/5/2012, the bank granted 10 lakhs. On account of the failure to repay the dues, the bank had declared the same as an NPA on 12/10/2022. And notice was issued under section 13(2) of the Securitization Act for outstanding liability of rupees 18,27,401. Then they have issued a 13(4) notice until symbolic portion of the property was taken on 3/3/2023. And the possession notice delivered to the petitioner, and a notice was also affixed on the outer door. And the bank has filed criminal miscellaneous number 298 of 2023 before the principal senior civil judge and chief judicial magistrate, Mangalore. And an order was passed appointing the advocate as court commissioner for execution of the warrant to take the possession of the property. When this matter came up before a coordinate bench of this court, an order was passed on 14/11/2024 directing issue of emergent notice to the bank, and an interim order is granted subject to petitioner depositing 15% of the outstanding amount due as of today within 4 weeks, failing which the interim order granted stands vacated. And the respondent bank is at liberty to proceed in accordance with law. The respondents have come up with a vacate petition stating that by suppression and misrepresentation of facts, the petitioner has obtained the interim order. It is stated that earlier he has filed WP 26599 of 2023, questioning the very same order under section 14. And an interim order was granted on 13/12/2023 on the ground that, on the condition that he shall pay 30% of the amount. And it is stated that without even paying the said amount, the petitioner on 4th November 2020 has withdrawn the petition, and has filed the
13th November 2020.
And immediately, when was it withdrawn?
My lords, it was withdrawn on 4th, my lord, 4th
4th
of November.
November. And immediately another writ petition is filed. The present writ petition is filed without suppressing all the facts and obtained an order on 14/11/2024. It is submitted that the petitioner has come before the court, the suppression, misrepresentation of the suppression of facts. And the writ petition has to be dismissed with exemplary cause. Next paragraph. Having heard the counsels on either side, there is a material on record. The petitioner has filed the earlier writ petition, enjoyed the interim order for almost a year, and had withdrawn it on 14th November 2024, and again filed this petition. In this present petition, absolutely there is no whisper about the earlier writ petition, the order that he has obtained from this court. This court cannot come to the rescue of a litigant who comes before the court with suppression and misrepresentation of facts. And those people are not entitled for any relief from the court. Accordingly, the writ petition is dismissed. How much costs? They have to pay a cost of rupees 50,000 to be paid to the.
5,000 here.
Why 5,000? You are enjoying it for 2 years.
He has no money. He has taken
But that's
education.
not right. That's not right.
Education loan here only. See.
So if it is education loan, every time you can withdraw one case and file another case, and also don't
I
have
don't
to
know,
say
madam.
anything.
Some other advocate he has filed here.
I'm not finding fault with you. Please understand that. I'm finding fault with your client. He has suppressed it without informing. He has not informed you. What is that you can do? 20,000 to pay to the Legal Services Authority. Yes.
Number 7, Sidramaya VP.
Here for recalling, the deficit court fee of rupees 500, it was not paid earlier. I have paid now, my lord. Last time, my lord, for non-payment of the deficit court fee. In fact, his petition is not liable to pay the deficit court fee. Since there is an objection, I have paid that also. Last time, registrar was directed to verify whether it was paid or not. Have the receipt also, my lord.
None appears to the petitioner and is pointed out by the office that the court fee has not been paid.
Yes.
And this is despite the fact that there is interim order which is continued.
Yes.
If court fee is not paid in all these months, that itself is a reason for dismissal of the petitions. The petition.
Sir, when the matter was come for preliminary hearing, we have argued and we have convinced the courts that they are not necessary to pay the court fee.
You were not present when the matter is
No,
called.
madam,
That's the
earlier
reason.
when the preliminary, sorry, my lord, that day I was held up in some other court. If earlier occasion, my lord, we have argued before this number court and convinced that they are not liable to pay court fee for each petitioners.
The
As
petition
there
is
belongs
fine.
to, now I have paid, my lord, that
Recall
also
of
I
the
have
order
paid.
dated 3rd September 2025, where the court had dismissed the petition on the ground that the order of the petitioner has not paid the court fee, and also there is no representation. Then counsel submits that though there was no deficit court fee, still he has paid the fee of rupees 500. And further on that reason, on that day, there was he was held up in the other court. As such, he couldn't appear before the court. Considering the same, the order dated 3rd September 2025 is recalled. Yes.
Interim order may tend to be extended.
When was the interim order?
My lord, last occasion it was extended. My lord, interim order was on
When was it dismissed?
3/9/2025, it was dismissed. Subsequently, it is extended, my lord. On last date of hearing, it was extended.
Now, without recalling the order, where is the point of when the writ petition itself is dismissed? Where is the question of extending the interim order?
The Honorable Court has considered the submission and extended it.
No. If an order is
Yes,
extended,
yes, I
in which
understand, my lord.
case
My bona fide submission has been accepted by the Honorable Court on earlier occasion.
your bona fide submission has to be accepted by recalling the order, not by granting
Yes, I
extending the
understand.
interim order.
At that time also, I
People have, where is the?
yes,
in
I am
which-
also under the impression that it was recalled. Today only I have noticed that it was not recalled.
Continued till the next date of hearing,
Yes.
in which case it will be continued Some High Court 001. The interim order earlier granted is extended till the next year. Who appears for the respondent?
My Lord, Joseph Anil Kumar.
Where is he? No representation for the respondent. Yes, next.
Cell number 8 urgent, cell number 9. Yashoda Regde, for petitioner.
I appear for the respondent bank in this case, my lords.
Petitioner.
What is this non-compliance of office objection?
Must have complied, my lords, with the objections.
The advocate for the petitioner has filed an application under section along with an affidavit praying to that the dispense with the production of certified copies of the annexure A and B.
That, my lords, is the.
Huh?
Let's annexure A, my lords, is the demand notice under 13(2).
Single judge with the production of certificate for the annexure A and B.
That's a 13(2) and 13(4) notice, my lords. Now 13(4) notice has since been withdrawn. My lords, what is challenged before my lords is, my lords, the classification of NP without extending the facilities, my lords, of the MSME under the section 9 of the Act, my lords, in the 2015 guidelines.
Yes, so office objections are overruled.
Please, my lords, I'm so grateful.
Yes. Wait, when is it? What is the interim order that is granted? Let us.
My lords, my lords, is coming up for the first time, my lords. There is no interim order as of yet.
This is 25587.
Yes, my lords. IA for dispensation has been filed, where minutes we sought for the dispensation of certified copy production.
Oh, next. Yes. No, I'm looking at the other one.
I'm so please.
IA number 1 of 25 is filed. No, IA number 1 of 25 is filed. Seeking dispensation of the certified copy of the annexure A and B. And you have filed the typed copies of the same or filed.
Please, minutes.
The IA is allowed. Yes.
My lords, my lords, I'm an MSME. My lords, I get a credit facility and a term facility about, my lords, 44 crores. My lords, I'm a going concern even as on date. I have a factory, my lords, I manufacture paper and packaging. So I'm a going concern, I have about 200 employees, my lords. My lords, I had my account initially with the Axis Bank, which thereafter, my lords, came to be taken over by the respondent bank, that is the Bank of Baroda. My lords, 44 crores of term loan and capital loan to two, my lords, about one agreement for about 7 facilities. That is, my lords, obtained. My lords, what happens is a demand notice, my lords, comes to be issued under 13(2), stating that, my lords, my account has been classified as NPA, my lords, on.
When does this?
My lords,
when does this?
my lords, 13(2), my lords, is on 15th of February 2025, my lords. That is when they say they're classifying my account. The date of classification of NPA, my lords, is on 12th of February 2025. Then, my lords, before that, my lords, in the month of January itself, my lords, I issue a communication. I request them that I'm still a going concern. There was a fire incident at the factory where, my lords, my godown was burnt. All my lords, supplies had gotten down. So I write to them stating that I'm still a going concern. I want to revive, my lords, my company. I ask for a restructuring. I say that please help me. I'm an MSME. I need some help from the bank, my lords, for me to go ahead and restructure.
With regard to this, what did you say?
My lords, for 13(3), my lords.
Your account as an NPA.
My lords, for that I issue a response, my lords, under 13(3) of the Surface Act, my lords, at page number 88, my lords will find it. At annexure E. My lords, I specifically say that I'm an MSME. That, my lords, there has to be a incipient stress identification, my lords, under the guideline. Please help me, my lords. In fact, I give a plan also. My lords, will come to page number 88. I'll just show that for 1 second. Under 88, my lords, annexure E. Lords, the objections under section 13(3)(a) of the Surface E Act, my lords, reference number 2. This is issued, my lords, on 12th of April. Soon after, my lords, the 13(2) notice was issued to me. I say that, my lords, this is my objections under 13(2). My lords, I take a specific defense, my lords, at paragraph number 6. In excess of the powers conferred in section 9 of the MSME Act, the central government, for the purpose of facilitating the promotion and development of MSME, has issued guidelines 29th May 2015. The notification pertains to the framework of revival rehabilitation of the MSME. No such efforts were made by your bank at any time for revival for unit. You are in abject breach of the said notification. I talk about SMA 101 and 2. Then, my lords, I say, my lords, we come to paragraph number 12, my lords.
Yes.
There, my lords, I say that the classification of NPA, my lords, without extending the benefit of the MSME notification, my lords, is not correct. My lords, this was received by the bank. Then, my lords, the response of the bank, my lords, will find it page number 95 at annexure F. My lords, it's a 4-paragraph response.
Yes, what do you say?
My lords, they say the contentions raised by you in reply to 13(2) is not correct. My lords, may come to page 95, my lords. I'm so sorry.
Yes, page.
95 minutes, annexure F.
Mm.
That is a consideration of my 13(3)(a). We state that the demand notice is issued as per the provisions of the SARFAESI Act. We further state that your loan account is classified as NPA as per the directions and guidelines issued by RBI. We state the total outstanding is 44.
The whole purpose of issuing a 13(2) notice is to consider the objections, and
My
then
lords.
mechanically the reply is given.
May I submit, my lords? See, my learned friend, he has suppressed two major things. One is this petition is res judicata in nature. So they have filed this very writ petition on
13th
19
of August, minutes are filed it.
13th of August.
So 18th of
Subsequent to
August.
that, they have filed one more essay before Honorable DRT on 22/9/2025 for the same cause of action. So they have successfully obtained the stay order from the DRT, that is an interim stay order. After that, court has given some instructions for directions for both of us. They said because that was filed on the basis of limitation expired, because there was a 6 days, they crossed the 6 days limitation based on the continuation of data application. They have filed a case. That case was registered in diary number, not essay, because since there is a delay, it was registered as diary number 1733 of 2025. And based on that, court also, and they were submitted before the DRT saying that, so we are the running concern, there are 200 employees are there. So based on that courtesy, the DRT has passed the order, and to prove the delay, they said after send that notice, after 3 days only we come to know, that's what we filed that's why we are delayed for 3 days. Basically that is 6 days delays, whatever. But still, court has directed them to produce the RPD covers which they have received. So, and the same court has told the bank.
Have they in the said application, have they stated about this pending petition?
Yes, supposed to say for the same 13 phone limit.
This was filed.
So after that, sir, let me finish. So after
that is subsequently, that's what I'm saying. About this writ petition, they have stated in that.
No, they have suppressed there also. So after this, my lords, and when the case was posted for filing for objections, on that objection, we tried to find out those RPD covers which we sent to the parties. Since there was 7 to 8 files, we have searched all the files and we were unable to find those RPD covers. And we have we have completed all the surface images. We have pasted on the door of the premises of the borrower, and it has been published in the newspaper within 7 days from the date of paste on the door. So those things have been complied.
What
So
happened?
after
Happened to
that,
them?
after that, then on the next date when the court has given for filing of objection, that time we as a bank admitted that, yeah, since we are unable to find out that time, so we are hereby withdrawing that 13(4) notice which is sent on 13/5/2025, which they challenge here and also there. So we have withdrawn that 13(4) notice, and we have issued fresh on 8/10/2025. That has been received from their side. We received that acknowledgement also. So they suppressed all these things. Suppressing that fact, they are telling all the stories and all these things, and they are wasting the precious time of this honorable court. So let them admit that first, then this court can. And since that 13(4) notice has been withdrawn, so this very petition will become infructuous. So no point of arguing the case.
Unless we come to para 54 of the petition.
No, how can you, having filed a writ petition here?
I have not challenged 13(4) notice.
When you approach the DRT, then all these issues
No,
will be dealt by DRT.
I have not challenged my lords the 13(4) notice. My lord, can you take my prayer? My lords, take my 54 paragraph number. My lords, I have specifically said that I have filed an essay. I have not, my lords, I have not misrepresented or my lords withhold the information. My lords, can you look at the prayer, my lords? Please.
After filing this writ petition,
Yes.
you have approached the DRT.
My lords, I had filed the application before the DRT first. The essay was filed first against the 13(4) notice. My lords, the DRT cannot consider, my lords, the classification of the NPA, my lords, without giving the MSME benefit. That, my lords, only this honorable court can consider.
Why?
My lords, because 13(4) is what I can challenge before the DRT under section 17. 13(2), my lords, 13(3)'s objection and 13(4)'s classification of NPA. There is no stage for my lords for the DRT to consider, or the power for the DRT to say that the classification of NPA, my lords, is not correct. Whether, my lords, 13(4) is issued in law, whether, my lords, the amount is due or not, whether, my lords, the proceedings center for recovery can be, my lords, proceeded or not, is something, my lords, the DRT can consider. My lords, I board on. If I challenge 13(4) notice here also and sought, my lords, for a stay of the auction, my lords, my learned friend is absolutely correct. My lords, I would have, my lords, filed 2 petitions on the same cause of action. Can you look at my prayer? I say that, my lords, I need to be given the benefit under the MSME, and the 13(2) classification of NPA has to be quashed. And my lords, consideration of my representation seeking for giving me the benefit. My lords, nowhere, even before the, my lords, the essay court, I did not say, my lords, my contention there was twofold. One, my lords, that the amount of 47 crores, what they say today, my lords, is not correct because I've not been given the documents. Second, that, my lords, the classic, my lords, the 13(3) consideration.
You have questioned 13.4 here.
My lords, 13(2), my lords.
4 also.
My lords, that's a consequential relief under 13(4). My lords, I will withdraw the delivery, I have no difficulty. My lords, my difficulty is this. The DRT, my lords, cannot go into whether, my lords, the notification under 2015 under Section 9 of the MSME Act, my lords, whether that should be extended to me or not. My lords, even today, my lords, they have issued a fresh 13(4) notice. My lords, I undertake to file an...
That for 13(2) notice,
Please.
you have issued a reply, your
Yes.
objections are filed.
Please,
That is dated under 13(3)(a).
please, my lords.
When is that?
My lords, that was given in April, my lords.
My lord, sorry for the interruption. Same copy paste have been challenged before the court, before DRT. Same 13(2) replay, all other things.
12th of April 2025 is when, my lords, I filed the...
If that's the case,
Please.
the DRT cannot consider all this. And according to you, they have not followed the procedure as per the MSME rule or whatever the notifications issued. What were you doing from April till now?
My lords, after April, my lords, I communicated.
What?
My lords, I sought for
Tribunal?
restructuring.
Huh?
My lords, I sought for restructuring. Only when they, my lords, I did seek for restructuring. I went to the bank and I said that, my lords, kindly give me, my lords, even today I'm willing to restructure the loan.
13(4), when was it issued?
My lords, 13(4), my lords, was issued on
13/5/2025. It is
13th of May, my lords.
So,
Yes,
even that time also that they have not considered your restructuring.
yes.
Then in that also this was available.
My lords, it was available. My lords, for,
Let them come up with all the objections, no urgency for this case.
my lords, may
The
only
counsel
make
for the
this,
respondent.
my lords, may make this submission.
Yes.
My lords, with respect to 13(4), my lords, I understand, my lords, my remedy is under Section 70, my lords, I'll avail it.
Even for this also, you had a remedy long back.
My lords,
Now,
may I, my lords,
conveniently, now you want to come before the court.
no, no, my lords, that
There is
has,
no urgency for that. Let them come up with their objections. We'll see.
no, my lords, the urgency is this.
Please, my
My
lords.
lords, as on date, my lords,
Ultimately, you want that notice to be set aside or the further proceedings to be stayed. That's why you are before this court.
my lords, for the
Because
further
we
proceedings,
already
my lords,
issued fresh 13(4). There is no question of granting stay or other things because, and they also know it. Before this, before the honorable DRT.
my lords, as on
I'll
date, my
file my
lords,
objection, my lords.
my lords, may I say this. Let's, as on date, I will not even
Lords,
pressing.
instead of coming
My lords,
directly.
either let madam
directly
let
come-
me
no,
speak.
instead of-
Let's, I'll wait.
Please
Let
wait,
let
let
madam
him
finish, my
submit.
lords.
Yes.
That's all I'm saying is this. As on today, my lords, I will not press for an interim order, my lords, because I understand, my lords, 13(4) they issued. I have to go before the DRT under Section 17. My lords, with respect to whether, my lords, 13(2) classification is correct or not, my lords, there is an urgency because, my lords, everything depends on that.
There
My
is
lords,
no-
if the
no, no,
13(2)
whenever
goes,
you feel the urgency, that is not the urgency of the
my
court.
lords, I bow down.
That is issue, you were very much aware of it right from April. And even after they have approached the bank, approached your.
Yes, I approached the DRT.
DRT. So that's in the 13/5/2025. Even by
Yes.
that date, you are aware. So no urgency today to pass any order on that.
Today, my lords, I
Let them come
understand.
up, let them come up with their objections. We'll understand, then we'll do it. Whatever contentions you have raised, they will file their objections to that. For objections of the respondent bank, list this matter on when?
Yes, my lords. By next month, my lords. Next month,
This
15th
matter,
onwards.
list this matter on 2nd of December.
My lords, may request
your
to take a
grace, my
memo,
lords.
my lords. I understand, my lords, my lords, as a borrower, my lords, I have 40 crores of liability. I'm liaising with the bank, my lords. It's not that, my lords, the first instance I can come to the court, my lords. They've got the advice at whatever point in time they've come to the court. I may have come a little late, my lords. I understand, I bow down, my lords, but that, my lords, that does not goes to say that, my lords, that I don't have, my lords, the seriousness, my lords, to contest the matter. This one, my lords-
Where did the court say that?
No, not that, my lords. The urgency is this, my
There's
lords.
no urgency.
My lords,
no
I have
urgency.
200 employees, my lords. It's a going concern, my lords.
200 employees is going around the DRT and all is happening.
My lords,
Not
it is
come
happening.
up with, because something has not worked out there, now you don't come up
My
with
lords,
the
it
new
worked
grounds
out there,
now.
my lords. I got to stay before the DRT. They withdrew the 13(4) notice, my lords. I am not, my lords, may I say this?
Unnecessary, they are causing very difficulty for the bank.
My lords,
filing-
they
keep-
don't
keep
issue
on
the
filing those
RPAD, my lords.
cases.
They withdraw the 13(4)
And,
notice.
those
My lords, I
cases
am not
also
unnecessarily causing anything.
certificate in nature.
My lords, there is
And-
nothing unnecessary here.
Matter on 19th of November, more than this, the court cannot do, Mr. Counsel. Yes, by the time the objection shall be placed on record.
Please, my lords, I'm grateful.
Please, my lords.
M.A. Rajendra, cell number 10, M.A. Rajendra.
Seek to appear for the respondent bank in this case. But there was a delay of more than 400 days.
Let's understand what is the case first. Yes.
Please to issue notice to the respondent, lords. Please issue the notice to the respondent, lords.
Yes. So and so is directed to take notice on behalf of the bank and shall file the objections
My lords,
by 9th of December. Yes, next.
Number 11.
Yes, I am appearing for petitioner, my lord. The petitioner is the borrower, my lord. Is challenging the notice issued by the bank, my lord, to taking the physical possession of the scheduled property, my lord. This scheduled property is a residential house of the petitioner, my lord. There is outstanding up to 1 crore 2 lakhs, my lord, as on 23/9/2025, my lord. Earlier, my lord, the borrower has filed SA, my lord, before DRT. DRT has granted interim order, my lord, subject to deposit of 25% of the amount, my lord. Is already deposit 20 lakhs, my lord. Therefore, the DRT has vacated interim order, my lord, and dismissed the case for non-prosecution, my lord. Now they have issued fresh notice for taking physical possession of the scheduled property, my lord.
So why should
There
this
are,
court interfere?
my
You
lord,
went
there
before
are-
the DRT, had an order, interim order, and it is dismissed for non-prosecution, so you will come to the High Court.
Thereafter, they have issued no fresh notice, my lord, taking physical possession, my lord. I have deposited earlier, my lord, 20 lakhs, my lord, as per the order of the DRT, my lord.
How can
Now
this
they,
court interfere, Mr. Counsel? If it is
I will
dismissed for default, you should file a petition for restoration and seek further order.
restoration petition until, my lord, subject to the deposit of the sum amount, my lord. This notice may be stayed, my lord. Otherwise, they will taking physical possession, my lord. I will deposit some amount, my lord, before bank, my lord, and thereafter I will file application for restoration of the that DRT petition, my lord. Some time may be granted.
Can the court grant such a relief as you are seeking?
Some time may be granted, my lord. I will approach DRT, my lord, for filing restoration.
Mahila Cooperative Bank, any counsel? Notice to the respondent.
Deposit some amount, my lord, 20% of the.
Notice to the respondent.
Cell number
Petition
12.
is the permitted to take out hand summons.
Any date may be fixed, my lord. Next week, my lord. I will serve. Any date may be fixed.
Yes. List this matter on 18th, if the memo is filed.
Please.
Cell number 12. Reading.
My lords, I pay for the petition. My lords, it's a SURFACE Act, my lords. There's a 20 lakhs due, my lords, as on the petitioner. But however, in the
What is the urgency? You have moved a memo.
my lords, for reasoning for moving the memo is, my lords, the bank, the officials and some other person who is not related to the bank, I came to the residential house and they made some galata in the house, my lords. I am moving out of the residential house. My only concern is that my 20 lakhs was due. However, in the month of 2000, in the year 2024 and the recent dates, I have paid another 4 lakhs. The outstanding was only 14 lakhs. The order for or the
No, what is
impugned
this
order,
20 minus 4 is?
it's around 4 lakhs, 6 lakh I have paid. The total outstanding principal was around 14 lakhs as per Annexure B, my lords, page number 27. My lords, only concern is I'm ready to deposit some amount.
No, some amount. Why are we concerned with some amount? Or who will deposit the remaining amount?
My lords, I may be permitted to, to speak with the bank with the OTS. And in the meantime, my lords, I may be not moved out of the residential house.
How can such an order be passed by this court? Unless there are any latches on the part of the bank in following the procedure, or you come up with saying that I will deposit that entire amount within 2 months or 3 months.
My lords, I'm ready to deposit the entire what is the outstanding within the 2 months of amount. As of today, I may be permitted to deposit some around 20% of the amount, and within 2 months or 3 months,
We'll
I may
take up this matter on Monday. Come up with such an affidavit.
My lords, because my lords, there is a phone calls regularly from the bank where that they are going to take the possession by tomorrow or Monday, my lords. That's the only reason.
No, I'll record that. The petitioner submits that till on instructions, and counsel submits that on Monday. They'll file an affidavit before this court that they're ready to pay the entire outstanding amount within 2 months from today. Shall record that. Then only I will pass some order. Or else even
My lords, in that case, I may be
that order also, I shouldn't pass. Because what is, when the DR, when you have other alternative remedies and without any basis, why should this court interfere?
Well, I may be permitted. I'll clear the entire outstanding amount within 3 months. And as on the Monday, I'll deposit 20% of the outstanding loan.
What is the 20% of the amount?
I deposit around 4 lakhs by Monday.
What is the notice that is issued now?
Well, it's an impugned order by the magistrate court.
14 order.
Please, madam. Page number
When
12.
counsel appearing for the petitioner, the present writ petition is filed, questioning an order passed in section 14 of the Surface Act. It is submitted that the property in question is a residential house, and in fact, the petition is ready to pay the entire amount within a period of 3 months from today. It is also submitted with the learned counsel of the petitioner that he will come up with an affidavit on Monday, undertaking that they'll be paying the amount by within 3 months, and they are also ready to pay an amount of rupees 6 lakhs.
4 lakhs.
An amount of 4 lakhs by Monday. This is matter on Tuesday. By the time.
I'm sorry, one submission. So tomorrow there's a bank holiday.
This
maybe
is
2
matter
days.
on also
2 days for bank transfer, 4 lakh, for depositing 4 lakh.
matter on Wednesday. By the time the amount of 4 lakhs, by Tuesday, the amount of 2 lakhs, 4 lakhs shall be paid, and an affidavit shall be filed before this court by Tuesday. If not, the bank is at liberty to proceed with the bank is at liberty on such deposit. There shall not be any the bank shall not take any coercive steps. If not, if the petitioner fails to pay the amount or file an affidavit before this court by Tuesday, the bank is at liberty. The petitioner shall take out hand summons. Which is this bank?
ILI.
IAFL
Any counsel appears for this?
IAFL Home Finance.
The petitioner shall take out a hand summons on the counsel, and also shall on the bank, and shall file a memo by Tuesday.
Well, still then no reciprocative actions.
I already said so.
Please.
Wednesday.
Cell number 13.
Affidavit shall be filed. Yes.
Sanjay Kumar K. for
Appear
petitioner.
for
the
appear
auction
for
purchase. Have not been
appear
made.
for petitioner's counsel, my lord. I seek your indulgence in a very brief manner, my lord. Your lordship may kindly see
The
page
auction
8.
purchase.
Instructions.
My lord, I have not been impleted. I am the auction purchaser. I purchased the property. Sale certificate is issued to me. It's registered. I have not been made a
And
party.
is the sale certificate?
My lord, if I may give. I don't have. I'll-
9/5/25 it was already.
9/5/25.
My lord, section 14 proceedings is initiated before the magistrate court by the bank. The loan that I borrowed was rupees 5 lakhs 10,000, 5 crores 10 lakhs 35,000, 5 crores. I have repaid 4 crores 22 lakhs 64,000. It is, I filed before the magistrate court. What I am due now is 87 lakhs 30,000. 87 lakhs 30,000 I am due to the bank now.
What is that to be borrowed? You said.
I
very-
borrowed 5 crores 10 lakhs. I repaid 4 crores 22 lakhs. I am due 87 lakhs rupees. I sustained severe loss in my business during.
What were you doing when?
No,
this-
I'll come to that. I'll come to that. Now, what has happened? The auction purchaser and the bank manager and the bank management people have colluded together and sold my 8 crores worth property for 2 crores 25 lakhs, which is a cheating for which I have filed a criminal case against them. And I have requested them give me 30 days time. I will pay that 87 lakhs rupees with the interest, and I also asked for a one-time settlement. They are not responding because there is a corrupt practice involving about 1 crore rupees corruption in the matter. My submission now is this, my lord. Today the matter is before the magistrate court to issue warrant through the police to keep me out of this house and to take the possession of the house for a paltry amount of 2 crores 25 lakhs, of which value is 8 crores rupees. I will deposit 87 lakhs rupees within 30 days before this honorable court.
Can this court pass an order? And already a sales certificate is also.
No, my lord, now the issue is only regarding possession, my lord. If I pay 87 lakhs rupees, the matter closes. He can take back his 82 crores 25 lakhs rupees.
No, the mortgage can be redeemed by you.
It can be done. It can be done within 60 days. If I return the money under the Surface Act, the property can be redeemed back to me. Now I am seeking the indulgence because the police will come and assault me and they will take possession of the property. They are highly valuable items in my property. 87, I will give an affidavit to that effect. Because I have been very prudent.
Why you have not approached this court or the DRT where you have a remedy or when the sale notice?
No, my lord. Now, my lord, the question is that I have already approached DRAT. In the DRAT, as directed, I have deposited some money also. I was not, the question that the auction purchaser, property auctioned, everything I come to know only at a later stage. In spite of my submission is only this, the issue now is only 87 lakhs. My loss will be 7 crores. I will be losing a property. So my under 226, my lord, this court has got an inherent power. As a human being, I have a right to own a property also. 87 lakhs in 30 days. It is in pipeline. It is coming money. Today I should have got the money. Within 15-20 days, I will pay that money.
Why should we interfere? That's the question I'm asking.
My lord, the question is there is an illegality, my lord. I have proved the illegality before your lordship.
How?
7 crores property.
How will the court know all this?
No, my submission may be recorded, my lord. 7 crores property has been sold for 2 crores 25 lakhs.
When was the sale notice issued?
Sale notice was issued, my lord, certain things has taken. We had
November of 2022. 3 years ago, auction has been conducted. This is the 6th or the 7th writ petition that has been filed by the
my lord.
8th writ petition that has been filed by the one writ petition is pending. 6 have been dismissed. SA is dismissed. One more writ petition regarding challenge to CMM order is pending. 6 writ petitions have been dismissed. The SA is dismissed. The stay they obtain, the interim order they obtain, they make a deposit. But after adjusting my amount, now the loan amount is closed. Now they are seeking benefit of my payment during auction to claim that there is very little amount due.
My lord, the question.
My lord, at this stage there is nothing to interfere, my lord, because it's been 3 years since it's been already.
Question here is let my friend come on record by filing an impleading
They should have
application.
impleaded me, my
Let him file an affidavit to that effect.
Suppress the sale certificate.
You are not on record. Please don't talk.
Tell the court in the petition where did you stay about the earlier writ petitions that are filed before this court?
No,
Earlier writ petition ಹಾಕಿದ್ದೀರಾ?
This is 8th round of litigation.
ಹೇಳ್ಬೇಕಿತ್ತಲ್ಲ ಹೇಳ್ಬೇಕಲ್ಲ ಎಲ್ಲಿದೆ? My lord, the earlier writ petition that has been filed under the Surface Act, my lord. Now it is regarding the magistrate court proceedings under section
So,
14.
A party who comes before the court, it is not necessary that he discloses what has happened.
That
in
has to be,
respect
that
of-
I agree, my lord, that has to be disclosed. That has to be disclosed. There is a bona fide.
It is not one petition, 6 petitions.
No, whatever it is, I will submit before the court in a direct.
Even about an essay that's your file, I mean, the DRAT where you have gone, what has happened?
No, my lord, now
You
the,
said that you come before the court.
no,
and file
now the question is only this, my lord.
The question will not decide, let them file their objections. Come on, the respondent shall file their objections. Yes.
Great.
My lord, my only submission, let them file a memo of calculation before the court.
Let them come up with, I'm not insisted, I don't want to say, insist them to file anything. Yes, next.
This
Matter on 9th of December. Yes.
My submission is 3rd or 4th of November. My lord. By then they will take.
Utterly, this is not a matter.
No, my lord,
for
the
that
police will go and take possession of the 3rd or 4th, my lord, because the difference is only 87 lakhs.
They can't file the objections in such a short time. Yes, that's the matter on December 2nd.
My lord, everything is with them, all the records. Only matter of our 2 days, my lord, that is sufficient to file an objection statement. Only
First of
submission,
all-
I will be losing,
First of
sir.
all, you have to file an petition before the court appropriate with all the relevant details. By the learned counsel appearing for the respondent bank submits that. This is still now 6 writ petitions are filed before the court. 7 filed or 6 filed?
7 filed.
7 filed, 6 dismissed, 1 is pending. And also they have approached the DRAT. The writ petition is absolutely silent on all these aspects. The petitioner cannot come before the court without disclosing all the earlier litigation with respect to the very same property. First, within a week from now on, the petitioner shall file the petition with all the relevant details, and the same shall be served on the bank. Then the bank shall file their response to the same.
Obliged.
Matter on 2nd of December.
Obliged.
Yes, next.
Clear number 14. Mohammed Tahir.
Yes.
Fairly, I'm submitting, Lordship. This is the first writ petition before this court.
Yes.
On this point, Lordship. Lordship, respondent number 1 is NBFC, and respondent number 2 is the Lordship Assets Reconstruction Company. Lordship,
Pyramid Finance Limited.
Yes, Lord. The petitioner has taken a loan from the bank, respondent number 1, for the tune of 1 crore 36 lakh, Lordship.
What is the order that is questioned before this court?
Auction notice has been issued, Lordship, e-auction notice. The reason, Lordship, what is my prayer, Lordship? They had sold, the respondent number 1 has sold the entire assets for 55 lakh, 50 lakh, 5 lakh, 20,000 rupees. Though they have received 95 lakh, 50,000 rupees from me in month of, in January 2024. Then they sold my asset to the respondent number 2 for 55 lakh rupees, Lordship. My only prayer before this honorable court, Lordship, as per the rule 38 of the SARFAESI rules, Lordship, there is a provision if auction purchaser is purchase a property and within 2 months, the borrowers approach to the bank and they ready
I'll
to pay
take up
10%.
this matter on Tuesday. Let the please take out hands on.
Auction is on Monday, Lordship. They quoted 1 crore 25. We ready to pay.
What were you doing till now?
We came to know on 10th October. We filed it on 14th October. We have filed it, this petition, writ petition. We moved a memo immediately after the vacation got over. We have moved it. Matter listed today, Lordship. For that reason, there is no delay from our part, Lordship. We came to know on 10th October. 14th October.
Without hearing the other side, I cannot stop this.
We ready to pay the entire amount. What they have purchased, 10% extra we are ready to pay. As per the Supreme Court judgment, Lordship, auction purchaser entitled to 10%.
What is outstanding as of now?
Lordship, the 50, they
forget about what they did. What is the outstanding amount?
Lordship,
I will say before the auction, if you pay the entire outstanding amount.
It is not the auction. It is not about auction. They had sold the entire assets to respondent number 2 for 55 lakh rupees. And 55 lakh rupees.
The auction is issued. That's what you said.
E-auction, they had quoted 1 crore rupees. 55 lakh rupees, they purchased the property. And now they are quoting for one.
That is not your problem. You have to pay whatever is the outstanding amount.
What
is the outstanding amount?
Kindly appreciate. Bank has closed the loan after receipt of 55 lakh rupees from the respondent number 2.
So you say that whatever is your outstanding, you will pay 55 lakhs to them.
No, we pay whatever amount they have purchased. Lordship,
that can't be. That can't be. Whatever is the outstanding amount, if you are ready to pay, I'll grant stay.
That is only because bank has closed the loan after receipt of 55 lakh rupees. So for the respondent number 2, we are ready to pay 10% extra to that. And as per the rule 38.
What is your outstanding amount? I asked that you are not.
I paid 95 lakh. Lordship, kindly see the.
What is the outstanding as on today? That's what I asked.
One-time settlement was happened in respect of 1 crore 35 lakh rupees. We paid 94 lakh rupees. 95
so what
lakh
is outstanding now?
Outstanding was at that point of time 45 lakh rupees. But subsequently, bank has sold my asset to the respondent number 2 for 55 lakh rupees. We are ready to pay 10% extra to the respondent number 2 to take back our assets. On that day, after receipt of 95 lakh rupees from the bank, the Lordship kindly see that this account statement page number 47, page number 17, Lordship. There 95 lakh rupees we paid to the bank.
I am not concerned with all that, and there cannot be any interference from this court. Only thing is, you please tell the court, forgetting about what they paid, you paid. what is the outstanding amount from your
That's
side.
45 lakh rupees. I have not paid that. I have not
Pay
paid
it
that.
now. You pay it
So
by
I'll pay
Monday.
it, Lordship, with reasonable
You pay
time.
it on Monday.
But within Monday, it's not possible. Some reasonable time may be given, I'll pay. Reasonable time is required. I'm bona fide. Lordship, I'm came here to with the offer that I'll pay 10% extra. I'm ready to pay. If reasonable time may be given, I'll pay, Lordship. It's not that I'm running away from the payment. Bank has already taken a money, 55 lakh rupees from the respondent number 2. Respondent number 2 has put an auction by quoting my property.
When was it given to the second respondent?
It is given on March 2000.
Then what are you doing from that day?
Lordship, we came to know only in October, Lordship. We are under discussion. The bank has not revealed this thing to us.
That's the reason why I say that we have to hear the bank first. Because you can say 101 things. Now, I'll tell you, there are cases where the interim order from the writ petitioner who is.
I'll take handsome money.
No, writ petitioner. No, I'll tell you what will happen if this kind of orders are passed. An interim order in favor of the writ petitioner asking him to deposit the money to the bank. Then an interim order in favor of the auction purchaser to pay the remaining amount. Now, what will the bank do now with both the monies?
I'm not
No
seeking any order,
submission.
Lordship.
If you are ready to pay 45 lakhs.
It is there on Monday. Monday it is the auction. Auction may be state, Lordship. Just
will not
4
stay.
weeks may be granted. Look, what will happen if somebody auction purchaser will purchase the property, one more party will be included with the money, Lordship. Lordship, my humble submission, Lordship, because they received the assets for 555 lakh. We are ready to pay.
Aware of the fact that.
Lordship,
this
we
property
came
is
to know
given-
when we got the notice. Before that, we had this thing.
And what are you doing? What are you doing without paying the money to the
We came
bank?
to know we are before this honorable court.
No, when did you negotiate with the bank? What were you doing when there is
We
an
sought for
outstanding?
time for payment for the prepayment of 45 lakh rupees. They have not granted in time. We paid 95 lakh rupees, Lordship. 95 lakh rupees we paid.
You are not doing any favor. That's what you are
We
supposed
have
to
taken
pay.
the money. We
Yes.
are not 45 lakh rupees. When we have not paid 45 lakh rupees, they sold the asset to 55 lakh rupees. Now the 55, the one who has received 55 lakh, he is auctioning our property for 1 crore 35 lakh rupees. Lordship. Tomorrow, if auction will happen, one more person will come say as a auction purchaser and claim equity before.
Not the reason why this court has to interfere.
Lordship, they are making profit out of my own assets, Lordship. When they have paid 55 lakh rupees, as per the rule 38, Lordship, there is a provision under rule 38. Even after sales has happened, if the borrower is ready to pay the money, addition to 10 place to the auction purchaser, then property will be handed over to him.
You know, even if Monday the auction is conducted, it will not be finalized immediately.
It may not be finalized, Lordship, but at least they should not issue a sales certificate.
You please take
Let the
note
auction to query only. They should not issue the certificate. I'll take a handsome one to the authorized officer. Let them come and we'll pay. We will make commitment before this honorable court.
Not necessarily. It will not be confirmed so fast. Monday, if the auction is going on, we'll take up this matter on Tuesday.
But
You
sale notice should not be.
you please serve the hand summons on the counsel for the respondent.
Lordship, there is no standing counsel for this. I'll take it for the
Do it
respondent.
personally to the bank and serve.
And someone else. The respondent,
Yes.
authorized
Petition
officer is in
permitted
Bangalore.
to take out hand summons on respondent 1 and 2.
Or 2, it's not
Matter.
possible, Lordship. Kindly see, respondent number 3 is in Bangalore. Other 2 is in Bombay and Delhi. He's the authorized officer, respondent number 2. So
He is permitted to take out hand
For
summons
respondent
on
number 3.
respondent number 2 and file a memo to that effect. If the memo is filed, this is matter on Tuesday. Yes,
Till number
but
15.
still then sales certificate should not be issued. Lord.
yes.
Obvious.
Till number 15.
Yes.
Showroom place.
Yes.
Page 38.
Protection of.
Lords,
CCL and
1
initiative.
1 crore 22 lakh 16,000.
I number 1 of 25 is filed seeking dispensation of the protection of CC of annexure E dispensed with. What is the impugned order?
Lords,
Annexure?
Lords, annexure D is the seizure notice. What they have seized the vehicles were hypothecated for a.
So even that also to dispense with the protection of the.
Lords, we don't
annexure.
have the originals.
I number 2 or 25 is filed so and so. Same dispensed with for the present. Yes.
It's page 38. Lords, the present due is 1 crore 22 lakh 16,000.
Hmm.
Lords, the loan which was initially borrowed was about 5 crores and odd. But now the outstanding as on today is this 1 crore 22
No, what
lakhs.
is that you are questioning it?
Lords,
Which is.
we have questioned the seizure. The seizure margins are produced. Lords, we are only making a statement, Lords, that 50 lakhs I'll pay within 4 weeks. against payments if they were to release the vehicles. I will give an undertaking for regularizing the account within a time to be stipulated by this honorable court. Or
No, they must have got enough time for all this. No, why should we put the clock back?
not, sir, the due is only 1 crore 22 lakhs as of today. Though the value of the
When it
assets
was,
is-
when the account was declared NPA.
Because the account was declared as NPA on 28/4/2025.
28/4/2025. 28/4/2025.
Yes.
Hmm.
But the certain times, the ups and downs in the business, sometimes this happens. This is a miscalculation.
But
we can take.
unfortunately, that's not the ground for the High Court to
Certainly,
interfere.
your lordships have been, the coordinate benches have been accommodating so that the bank will also get the payment. Ultimately,
That's what the
lords,
Honorable Apex Court said, don't do it.
lords, now ultimately what happens, the
And also
vehicles.
you must have seen the recent judgment of the Honorable Apex Court, where it is, how it has heavily come down.
But see, the bank recovery processes, it says that if circumstances are there, 226 is a jurisdiction, which is plenary in nature. The Supreme Court itself, the Constitution bench itself said that it will not be proper for us to regulate how 226 is to be exercised. It's a self-exercised restraint which
No,
will be
but it
exercised
is
by the
very
court,
clear.
no guidelines are
You
laid
have,
down.
there are the tribunals,
justice-
forums are created for that. And why are we circumventing that process?
But I don't
And
say-
interfering in matters where they do not even raise a legal issue. That's
This-
a whole,
This is not in the strict sense under the Surface Act.
then it is not, it will not come before
No,
this
no,
court.
it's by the bank which has exercised its powers for the, under the hypothecation agreement, saying that because this is the dues, we want to repossess the vehicles. Not without demur or protest, we gave back the possession. There is no question of holding back because we knew that we have defaulted. Not 1 crore 22 lakhs is what is due as of today. I'll pay 50 lakhs within 4 weeks. Against that 50 lakhs, let them deliver. If I generate business, I can.
You are it, or instance, set aside the order, letter dated, issued with the respondent, bearing so and so. So the proceedings are not under the Surface Act.
Lords, in the strict sense, the seizure is not there, but now they have initiated the proceedings. If your lords were to see.
So when you're not questioning anything under the Surface Act, how the writ will come before this
But
court?
the action is by the bank, the action is by the nationalized bank. That's the SBI, which wants to take action in respect of the dues excising powers and the surfacing. But the courts have taken a very consistent view that when exercise of power is under the hypothecation, there is no question of forcible taking of possession of the properties. That is the view taken. Not, I'm not standing on any of those technicalities. I'm only seeking an accommodation to facilitate that I can pay this amount because the bank will have some restrictions in the manner because they're also bound by some RBI regulations which may not permit them. So these are the circumstances where we seek your lordship's indulgence. If some facilitation is given, my lords, now if these lorries are.
Let's hear the bank also before passing any such order. Who appears as State Bank of India? Who is the counsel?
Vignesh Shetty appears.
Mr. Vignesh Shetty is directed to take notice and the counsel for the petitioner shall serve the copy of the writ petition on the counsel. This is matter on Monday.
Please.
Cell number 16. Parameshwarappa MV.
For petition, Your Honor. Petitioner filed a petition for the challenging the e-action notice issued by the respondent 1 and 2 bank, Your Honor. The petition is not availed any loan. She is the bona fide purchaser from the, as per the sale deed exhibit, annexure D. She has the purchase from the
2410 is yesterday.
no, yesterday. The auction is not conducted, Your Honor. We are already approached morning. They are
Then
saying
it
that
becomes
auction is not conducted.
It becomes infectious.
On my submission, Your Honor, that my humble submission kindly issue notice because as per the e-auction notice, they are mentioned the outstanding rupees.
And so, and quash the e-auction sale notice dated 26/9/2025. That is 24. Instead of 24, you said 26.
Yes,
So
yes.
what is to be done now?
As per the e-auction, they are mentioned the outstanding dues of 52 lakhs in something, Your Honor. Yes, morning their petition is approached the bank. They are saying that you have to pay 21 lakhs. We are ready for settlement. Since this honorable court is granted interim order, but we have deposit amount that is not possible to petitioner to pay that amount, Your Honor, because she is not the bona fide purchase. She is not availed any loan from the respondent number 1 and 2 bank. Respondent number 3 and 4, they are the avail the loan from the respondent number 1 and 2 bank, Your Honor, during the year 2019. But she is the purchase the property from respondent number 3 and 4.
Not going to all that. You have questioned the auction, that auction is not.
Auction is not
So
conducted.
what remains to be decided in this?
Kindly issue notice to the bank, because Your Honor, that they have already approached the bank for this for settlement.
Understand, the cause of action for you is no more surviving now.
But they are already told we are.
That is the main prayer itself is questioning the notice.
Yes, Honor, one more submission. They are already told to the petitioner to we are conduct the auction on 4th of November.
Then you have to question that.
Again, they are not issued any notice because she is not the borrower.
So what is to be done? Why should
Number
we issue
submission, kindly
notice
issue
now?
respond number 2 the notice, Your Honor. They are, if they are.
Absolutely no rule and rhyme for filing these writ petitions.
Because only principle of justice, Your Honor, they are
What
not
principles of
available.
justice? That's what we have to follow.
Because they-
Unfortunately, we are not following that. No natural justice, no notice to the other side.
Honor, my humble
Whatever the
submission,
petitioner comes,
they are
no,
not
some
issued
order
any
to be
13.2
passed.
or 13.4 notice to the petition, Your Honor. Only they are affixing the
This
notice.
Repco Home Finance Limited.
Yes, Your Honor, they are only affixing notice scheduled property in e-auction sale notice on 16th of this month. But without giving any notice to the.
List is matter on 18th of November. Yes. Let's see.
Serial number 17 adjourned, serial number 18.
No representation. Let's see, the memo is moved. You moved the memo.
No, I am for, my lord, I am for 19.
You are for the?
Serial number 19.
18. Mali Patil PS. Uma
A
Shankara
memo
S.
is moved on seeking a urgent listing of the matter, and the matter is listed today. And in spite of that, there is no representation on behalf of the petitioner. This is matter on 25th of November.
Serial number 19.
Lord's
R.V. Srinivas Reddy.
We will be passing the orders every day, but again it is relisted.
Which one?
Serial number 19.
That day maybe the time is not there. What is this?
The petitioner said he'll pay the principal amount in 8 days.
That's what she was asked. That day what has happened, what she's was saying is that even for paying that amount also, somebody is not well, something she said.
So that's 1 week, your lordship may give 2 weeks time and pass.
No, not for 1 week, 2 weeks. She said still she has to get instructions. It's 2 months or 3 months. I said I'll dismiss it, get final instruction. No representation. This is matter for dismissal on Tuesday.
Serial number 20 adjourned, 21. Serial number 21. MS.
Yes.
My lord, the main relief, my lord, which we assign, my lord, is for writ of mandamus. Mandamus we have sought, my lord. Because the, my lord, she is neither the owner, neither the borrower nor the guarantor, my lord. She is only a successor to the property is concerned, my lord, is secured property. My lord, principal borrower, she died in 21. Our consent witness, the son is also died in 2024, my lord, last year. My lord, she is not only the legal heir of the principal borrower. My lord, there are other 4 daughters also there remaining. My lord, the bank, my lord, see, considering that, my lord, there is a loan is still considering more than 36 lakhs as a due in respect of the loan, my lord. She made, voluntarily, she made a representation to the bank. Wide annexure C, my lord, please, annexure D. That is in page 50, my lord, annexure D.
Page number?
Page 15, my lord, please.
Page?
50, running page.
Yes.
50, please. She made a, voluntarily she made a representation on 31/12/2024, my lord.
Then?
Seeking one-time settlement, considering that, my lord, she is not in a position, but they are not considered it.
I will check the instruction, madam, bank instruction.
Get instructions.
Today is the bank holiday, madam.
That's what, get instructions.
Yes, ma'am.
This is matter on.
My lord, after this, my lord, after 4 months, they have initiated the proceedings.
This is matter on 4th of November. By the time the petition shall get specific instructions. Yes, next. Any signatures?
ಸರ್ ಇದೆ.
ಮೇಡಮ್ ಫಾಸ್ಟ್ ಫಾರ್ಮ್ಯಾಟ್ ತಗೊಂತಾರ ಎರಡೂವರೆಗೆ.
So list number,
ಮೇಡಮ್ ಫಾಸ್ಟ್ ಫಾರ್ಮ್ ತಗೊಂತಾರ ಎರಡೂವರೆಗೆ.
list number 4 ಇಲ್ಲ, list number 4.
ಇವ್ರೆ ಅಲ್ಲಿ ಮೆಮೋಸ್ ಅಲ್ಲಿ ನೋಡಿ, ಮೆಮೋ ಅಲ್ಲಿದೆ ನೋಡಿಪ್ಪ. ಏ ಅದ್ ಕೊಡಮ್ಮ ಅದೆಲ್ಲ. ಲಿಸ್ಟ್ ನಂಬರ್ 2. ಆಯ್ತು. ಅಷ್ಟೇ ಅಷ್ಟೇ. He was not there. Like that. ಅಲ್ಲಿಂದ ತೆಗ್ದು ಅಲ್ಲಿಗೆ ಹಾಕೊಂಡವ್ರೆ.
ಅದನ್ನ ಸಪರೇಟ್ ಹಾಕ್ತೀನಿ, ಮೂರನೇ ಲಿಸ್ಟ್ ಕೊಡ್ತೀನಿ.
ಸರ್ 3179 ನಿನ್ನೆ ಇದೆ ಮ್ಯಾಟರ್.
ಮೆಮೋ ಕೊಡ್ಬೇಕಾ ಮೇಡಮ್?
ಅದು ಕಂಪ್ಲೇಂಟ್
ಮೆಮೋ ಇಲ್ಲಿ ಕೊಡ್ಬೇಕಾ ಅಂತ
ನಾನ್ ಕಂಪ್ಲೇಂಟ್
ಅದಕ್ಕೆ ರೆಡಿ ಇರೋ ಮ್ಯಾಟ್ರಸ್ಗೆ
ಕಾಂಟ್ಯಾಕ್ಟ್ ಲಿಸ್ಟ್ ಆಗತ್ತೆ ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಕೈಲೇ ಹೋಗಿ
ಲಿಸ್ಟ್ ಎಲ್ಲ
ಇಲ್ಲಿ ಅದರಲ್ಲಿ
ನಿಮ್ಮಲ್ಲಿ ಯಾವ ಈ ಇಯರ್ ಡಿಸ್ಪೋಸಲ್
31731 ಸರ್. ನೀವು ಒಂದೇ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕ್ಬೇಕಷ್ಟೇ.
ಅಪೋಸಿಟ್ ಸೈಡ್
ಇವಾಗ ಹೋಗಿ ನಿಮಗೆ ಬರ್ಲಿಲ್ಲ ಅಲ್ಲಿ. 731 2025.
Monday better, 29th of every Monday.
ಆಯ್ತು ಸರ್, ಚೆಕ್ ಮಾಡಿದೆ ಸರ್ ಫುಲ್ಲು ಅಲ್ಲೆಲ್ಲೇ ಇಲ್ಲ. ಹೌದಾ? ಎಲ್ಲಿ ಚೆಕ್ ಮಾಡಿ ಮತ್ತೆ ಅಲ್ಲೇ ಹೋಗಿ ಚೆಕ್ ಮಾಡ್ಬೇಕಾ ಸರ್? ಡೇಟ್ ಅದೇ ಇವಾಗ ಹೋಗಿ ಚೆಕ್ ಮಾಡಿದೆ ಅವರು ಇಲ್ಲ ಡೇಟ್ ಇರೋದಾದ್ರೆ ಪೋರ್ಟಲ್ ಇರುತ್ತೆ ನೋಡಿ ಅಂತ.
ಆಯ್ತು ನೀವು ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಪ್ಡೇಟೆಡ್ ಅಲ್ಲಿ ಈಗ ಏನಿದೆಯಲ್ಲ ಅದ್ರಲ್ಲಿ ಇದೆ 3 ಕಂಪನಿ ಇದೆ.
ಅದೇನೋ ಬ್ಯಾಟ್ರಿ ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ ರಿಪೇರ್ ಮಾಡ್ತೀವಿ.
ಮೇಡಮ್ ನಿಮ್ಮೊಂದು ಸಬ್ಮಿಷನ್ ಅವರೇ ಇರ್ತಾರಲ್ಲ ಸರ್ ಅವರೇ ಮೆಮೊ ನಿನ್ನೆ ಬೆಳಗ್ಗೆ ನೋಡಿ ನಿಮ್ಮನ್ನ ಕೇಳಿದ್ದೆ ನಾನು ಸಬ್ಮಿಷನ್ ಮಾಡಿದೆ.
ಅದೇ ನಿಮ್ ಫ್ರೆಂಡ್ ಜೊತೆಗೆ ನಿಮ್ ಫ್ರೆಂಡ್ ಜೊತೆಗೆ ಹೋಗು ಅಲ್ಲಿಗೆ ಕಳಿಸ್ತೀನಿ. ಇದ್ರೆ ಹೇಳಿದ್ರೆ ಹೇಳ್ದೆ.
Seat number 97 ಅಲ್ಲಿ ಇನ್ನೊಂದು connected matter ಇದೆ. 6/12/24 ಫೈನಲ್ ಇಯರಿಂಗ್ ಇನ್ನೊಂದು connected matter ಇದೆ 6/12/24 ಇದೆ ಅಂತ ನಮಗೆ ಆಗ್ಬೇಕು. ಆಯ್ತು. ಯಾಕೆಂದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ ಅದರಲ್ಲಿ ವಿತ್ಡ್ರಾವಲ್ಗೆ ನಾ ಹಾಕೊಂಡಿದ್ದೀನಿ. ಅದೇ ಹೀರಿಂಗ್ ಆಗ್ಬಿಡ್ಲಿ ಅಂತ ಸೋಮವಾರ ಹಾಕ್ಸಿ ಕೇಳ್ತೀನಿ ಮಂಡೆಗೆ. ಮಂಡೆ ಆಯ್ತು, ಏನಿಲ್ಲ ಡಿಸ್ಪೋಸಲ್ ಆಗ್ಬಿಡುತ್ತಲ್ಲ ಅಂತ. ಓಕೆ
Madam, list to serial number 18 ಏನಾಯ್ತು madam? List to serial number 18. Yes, madam. Respondent ನೀವು ಮಾಡಿದ್ದೀರಿ. Okay, okay. Date 25/11 ನಾ?
ಲಾಸ್ಟಿಗೆ ಎಲ್ಲ ಅವ್ರು ಸಿಕ್ಕಿದ್ರಪ್ಪ ಇಲ್ಲ ಯಾವ ಸೆಲ್ ನಂಬರ್ 75 ಬೈಲೇಬೇಕು ನೋಟ್ ಮಾಡ್ಕೋಬೇಕು. ಡಿಫ್ರೆಂಟ್ ಕಾಪಿ ನೆಟ್ಟಲ್ಲಿ ಇಲ್ಲ. ಅವ್ರೆಲ್ಲೂ ಕಾಣ್ತಿಲ್ಲ ಬಟ್ ಅವರು ನಮ್ಮ ಮುಖ ನೋಡ್ತಾರೆ, ಅದಕ್ಕೆ ನಾವು ಮೇಡಮ್ ಅವರು ಅದಕ್ಕೆ ನಾವು ತಗೊಂಡೋಗಿ
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮುಗಿದಿದೆಯಾ? ಮುಗಿತಾ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್? ಒಂದಿದೆಯಾ? ಥರ್ಡ್ ಲಿಸ್ಟ್ ಐತೆ ಅದು.
Pass over matter, list one, seal number 1. Girish B. Baldare.
For petitioner.
Can you change the adjustment of the chair? Adjustment of the chair.
Being spoken.
Yes. How can you file this order when a separate order is there?
I make an inquiry with my counterpart advocate while filing the petition, my lord.
No, it
He
is-
informed that there is no.
Orders pronounced in the open
seen
court as
the-
follows,
I-
by separate order.
by-
I'll give you the order copy.
Only I came to know, my lordship.
And once the order copy is there, there is nothing to remand this matter now. Because the judge has considered whatever I have said so.
My submission is already the 9,000 is awarded, my lordship, under the TV Act for 3,000 each. And the custody was.
The order
given-
is, having heard the learned counsels on either side, in spite of repeated orders passed by this court and the directions that are issued on the judicial side and on the administrative side, this court is not able to understand why the family courts are not following the law laid down by the Honorable Apex Court in Rajni's case refers supra. In all cases, again, this court has to remand the matter and it is giving rise to unnecessary litigation. When the family court is passing an order, it should be a reasoned order. Unfortunately, the family courts are passing so and so. That's the only reason why the matter is remanded. In fact, in a review meeting, I asked him why these kind of orders are passed. Then he has sent this order. So Let's see the order that is passed. Even till now, your client has not given that.
No, my lordship, that is the practical difficulty what I am facing, my lordship.
Because it is convenient to him.
And in this case, my lordship, I also produced the assets and liabilities in the criminal petition under filed under the DV Act.
Where is that order copy? In this order copy, that the Registrar R&S has placed, that's how it is here.
Page number 65, my lordship.
It's by the advocate for petitioner. There's nothing in the file. I didn't see in the morning also. Yes, place along with the order copy. Yes, on 4th of November. Yes.
Serial number
Fifth or
5.
sixth, my lord. By that time, I'll secure the order copy.
6th of November.
Serial number 5, list number 2.
Yes.
I appear for the petitioner, my lord. As my lords instructed me, I have inquired with the client, my lord. For a moment, I'll take my lordship to Annexure D. Even the notice which has come to me, I have annexed. There is no suppression of any document, my lord.
No. What
Please.
I asked you specifically is, till you receive this notice, you are not aware of any of the proceedings that are initiated by the bank.
No, my lords. Straight away, I get a notice of Annexure A and A1
On what date?
on, as per the letter 9/10/2025, the letter was received through registered post, my lord, on 14/10/2025.
What is that letter you have received?
Letter stating that the reference letter saying this has reference to the loan hypothecation agreement dated 4/3/2024 executed by you. Since your inability to pay the loan installment under the above said contract, we have repossessed the vehicle bearing registration number KA11C6460 on dated 12/8/2025. Since there is no response from your side in respect of the settlement of the above contract, we are proposed to sell the above vehicle in its as is where is condition.
Then what did you do?
What?
Then what you did? What your client did?
But after I received this letter, I immediately contacted them saying that I want to take back the vehicle because the vehicle was on contract, which was working for the government agency.
When did you approach them?
But soon after, when on 13/8/2025 itself, 13/8/2025, why I approached on
You're
13.
not aware of anything, then why did you approach them?
Well, the crux of the issue is this, my lord. What had happened, for a moment, I'll take my lordships to page 32. There is an FIR against them. What happened on 12/8/2025, my tipper vehicle was running around Mangalore zone for dumping of all the materials. On 12/8/2025, all of a sudden, their agents come and take back my vehicle.
No, bank has initiated proceedings under which act?
But they doesn't say anything, my lord.
That is not under the Surface Act.
They just say we are going for selling the vehicle.
But I'm saying that is not under the Surface Act.
And hypothecation will be done by bank, no, my lord. So if they want to sell, they need to follow the procedure of the Surface Act. Because they take agreements, they take my checks, everything when they want, when the loan is availed, I need to sign everything, my lord.
They have not initiated the proceedings.
So, pardon, my lord.
They have not initiated any proceedings on the Surface Act.
My lord, they say we are ready to sell the vehicle. Then the only remedy before my lordships is available.
What is the roster this court has got?
DRT, because it's a bank, it's a
Debt recovery
institution.
tribunal, Surface Act proceedings.
But
And every transaction between you and the bank, hypothecation, loan agreement, everything will be part of this.
my lord, I bow my head towards my lordships, whatever my lords is stating. For a moment, this court is empowered to allow this petition for a moment. The illegal activity, how they have carried out, my lord. They have not even issued the seizure notice at all. All of a sudden, they harassed me to an extent where a 307 case has been booked, my lord. They have attempted murder on my drivers, my lord.
Anybody who appears for the bank here? Any counsel?
This bank is situated, the main branch is situated in
Not about this bank, any bank, council, bank council.
Sundaram, nobody. Even I inquired, my lord.
When it is not part of the bank, part of the surface proceedings, if any basing on a contractual obligation between the parties, if they're doing something, then what are you supposed to do?
If there is any loan agreement to that extent, if any clause is mentioned, I could have approached any other forums.
No.
It's a blanket intimation letter which has been given to me.
Not when it is not initiated in the Surface Act, then your remedy is to file a suit. Restraining them from alienating the property.
They say the vehicle will be sold on, my lord, because it's a bank, it's an institution. This court is very much empowered to pass an order, my lord.
Unfortunately, we are extending the scope of the litigation.
But if there is no any illegality, I would have accepted, my lord.
Every illegality is not, will not fall within the jurisdiction of this court.
Lord, it's even equitable grounds on seeking the such, and because today is the auction, my lord. I don't have any alternative. My livelihood is entirely dependent on those vehicles.
No, I'm not convinced with all these things which you are saying.
Usually when there is such any letters correspondence, we are under the practice of coming before the High Court on.
So that practice, we have to slowly deviate from that practice.
No, this is the.
For everything coming to the High Court, the practice should be deviated.
There was no any other, because the letter seemed, because I have hypothecated to the bank. So on those grounds, I have approached.
The submission of yours, the court is not believing. Because there must be some communication which will 100% come before this court once the bank comes before the court.
To that extent,
Till
they are hurrying up with all the process without giving me a reasonable opportunity at all. When I am ready to redeem the vehicles.
Opportunity or reasonable opportunity?
But all of a sudden they say I will sell the.
No, opportunity or reasonable opportunity. No opportunity is given to you till now.
By the bank, my lord. Nothing. If my lords look at whatever the notice I have received, whatever the document, even in response I have approached the bank. Thereafter, the amount of harassment they have done, the photographs is apparent on the record, my lord. Even the complaint FIRs on them. Well, this part of this petitioner stay in a town, a village called Maddur, my lord. They load all the materials belonging to the government agency to dump to provide for roads, tar, everything. The business was so dull, even the government did not give the bill which has to be given by contract basis, my lord. In spite of that, they tried their level best to pay the EMIs. All of a sudden, their agencies comes and does such an activity, my lord. My entire livelihood, my entire loan, I'm ready to pay the EMIs.
No, against Sundaram Finance, how the writ petition is maintainable?
They are the one who have issued the letter. For a moment, Annexure A, page 18, my lord. By reference number dated 9/10/2025, the authorized signatory is Sundaram Finance Limited.
No, this court interferes in this petition, then I have to pass orders in every case of this nature. I'm not inclined.
Today being the last date, my lord, I am ready to redeem my entire vehicles, my lord.
If you have done it, the bank would have not done.
No, my lord, there was no
Why you should wait till the orders are passed by the court?
My lord, I had approached them. Even there was a mediation, my lord, Annexure D for a moment, my lord. I have even attended mediation.
Don't want money.
My lord?
Bank do not want money.
But they demand 50 lakhs, my lord.
Whatever is the amount they will demand.
But the amount availed was 50 lakhs. I have paid diligently till January. Sorry, I keep correct, my lord, till May. Thereafter, my lord, I am ready to pay. Only 3 installments is pending, my lord. I am ready. If they say, for a moment, my lord, see, I will point out the description in this Annexure A, my lord. They say you are called upon to settle the contract before 25/10/2021, or if you have any better offer for the sale of the vehicle, we hereby call upon you to intimate the said offer to us before 15th October 2025, together with the payment. My lord, I did not receive the letter on that day itself, my lord. This is the postal acknowledgement due card also, my lord. After the appropriation of the said sale proceeds towards the amount due in respect of the said loan hypothecation agreement, we reserve our right to proceed against you for recovery of the shortfall amount. In spite of me paying EMI also, they say there will be shortfall of amount, my lord. I am not ready to give up my livelihood, my lord. The vehicles are the one where I am surviving.
We'll have it on Tuesday. Let the that finance company come before the court. The petition is permitted to take out hand summons on the respondent. If the memo is filed, this is matter on Tuesday. Yes, next.
And summons.
That
Hand
matter
summons.
moved at-
Obligation.
Yes.
Matter moved at-
Yes.
The matter moved at end of the list. Syed Jafar Mohiuddin.
Ladyship, appearing on behalf of the petitioner in this case, my lord. Ladyship, I had availed a loan from the respondent bank. In 2017, 1 crore loan was sanctioned to me. For that 1 crore principal amount, I have so far already paid 1 crore 1 lakh in EMIs. Now, your ladyship, section 13.2 notice and section 13.4 notice is alleged to have been served to us. Now, my lordship, I'm taking this court to the loan statement that we have produced before this bank, before this honorable court at annexure A, your lordship. Here, your lordship, the EMI payments, we are continuously paying the EMIs. I have produced the entire loan statement, your lordship. For the past 2 years also, there is no delay on my end. We are in continuous contact with the bank. The bank is happily accepting our EMIs. They are continuing with the loan, and without giving us an opportunity, there are talks going on for we finding the loan being of a higher rate of interest. We were in talks of changing the bank so that loan can be taken over by a different bank. Now, your lordship, the bank has come up with this section 13.4 notice, and they have given us 2 weeks time to vacate the property. And the 2 weeks time ends today. Your lordship, the loan account statement that we have produced before this bank clearly demonstrate we have no intention of cheating the bank in not even a single penny. We are
For invoking the provisions, you don't have the intention of cheating. If you're a defaulter, that is sufficient.
Your lordship, such information was not timely communicated to us. We are continuously in conversation with the bank. The amount that is being paid.
Bank it is.
Bank at annexure A, your lordship.
Bajaj Finance.
Bajaj Finance. At annexure A, we have produced the entire loan statement up until the 7th month of this year also, because the loan statement is made available to us until August. That loan statement, entire loan statement, we have placed it before this honorable court. We are continuously paying our EMIs and dues. Now they issue us a notice saying that in 2 weeks.
Unless and until your account is declared as an NPA,
Please, your
question of initiating the proceedings does not arise.
Please, your lordship.
So it must have been declared as NPA long back.
That is the allegation. That is the alleged.
Come to your statement. Let us say.
Now, your lordship, the statement of.
How did you get this notice under 13.2 now?
Your lordship, 13.4 notice
13.2 notice. Where from you got it?
When we visited the bank, that is when we were supplied the copy of this, and then, your lordship, the property wherein the suit schedule property is occupied by my tenants. 3 days back, the tenants call us and inform us that the bank authorities have come before this building and stuck the final vacate notice saying that the building has to be vacated and they'll be exercising possession over this property. Immediately on receipt of such information, we go and visit the bank. That is when hard copies of these notices.
The monthly installment is 1,32,449.
Please,
Let
Your
us see-
Lordship.
Let us see, where is that, when did you last pay? Where is the bank statement?
Bank statement is at annexure A, Your Lordship. Ink page 45 is the last page of the statement, Your Lordship. Ink page number 45 is the last page of the statement. At 2nd of July 2025, the credit amount clearly discloses 1,32,449. That was the prevalent EMI. We are continuously paying, and in the chronological order, if we follow the statement backwards, my lordship, there is no EMIs that we have defaulted for the past 2 years also. We are in continuous contact with the bank. With the intention of us having this contact with the bank was we are trying to change the lender so that the rate of interest comes down. Meanwhile, these are the thing that in a clandestine manner we have been served upon such notice, and we have been put to great difficulty, Your Lordship.
Why in the same month we see that there are 2 entries? What is the statement? I'm not able to understand.
Your Lordship, the credit transaction.
Page 44.
44, yes, Your Lordship.
44, 2/4/2025, 1,32,000.
Please, Your Lordship.
449.
Please, Your
Again, the
Lordship.
next page, why there is 2/4/2025? Payment bounced.
Yeah, that is debit.
Payment bounced, payment stopped by drawer. 2/4/2025.
The installment is cleared. Your Lordship, the
Payment
presentation.
bounced, payment stopped by drawer. Then wherever there is entry, payment bounced, payment stopped by drawer. First, whatever entries you are referring to,
Please, Your
payment presented. Then payment bounced, payment stopped by drawer. Payment bounced, payment stopped by drawer. That is all the entries. I think you have not seen the statement.
Your Lordship, we are ready and willing to make the
No,
payment.
no, please don't tell all that. You stick to your statement, what you have made. Your
Please.
statement is that you have been continuous in paying the amount.
Please.
And even till latest till 2/8/2025 I have paid, and my account is declared as NPA. But
Please,
that
Your
is not so. Payment presented on EMI number, that is on 2/8. Payment bounced, payment stopped by drawer.
Your Lordship, if one opportunity is extended to us.
On that ground, we will not interfere.
No, my Lord.
There has to be some legal grounds, Mr. Counsel. I will not pass any orders in these matters. Either first, without any legal ground. Number 2, without the presence of the other side.
Lordship, if hand delivery is given to us, Lordship will deliver it on
Let them
the.
do it. This is matter on Tuesday. By the time, if you can serve the hand summons, I'll take up the matter.
Please, Your Lordship.
If what, now, who is the court to say, okay, please, give them installments, give them that, give them this.
No, Your Lordship, if.
Now, if it is a settlement, should be agreeable to the other party.
Please, Your
Not to the court.
Please, Your Lordship.
Because court is not giving the money to you.
Please, Your Lordship.
List this matter on Tuesday.
Your Lordship, if some interim protection is provided, Your Lordship,
petition
the
is permitted
vacate
to
notice.
take out hand summons to the respondent and shall file a memo to that effect. If the memo is filed, list the matter on Tuesday or Wednesday.
Please, Your Lordship. Any day that is convenient to this court, Tuesday should be.
Either way, it's convenient to the court. When
Tuesday.
can you file the memo is the question.
Tuesday, Your Lordship.
Yes, if the memo is filed on Monday, list the matter on Tuesday. And first of all, before making any submissions so assertively, we should look at the papers.
Please, Your Lordship.
And you say that we have paid, just you're seeing one entry.
No,
And it blatantly shows that from the last at least 8-9 months, every time there is
Your
a.
Lordship, outstanding amount in that 1 crore, 1 lakh, we've already paid for a loan of 1 crore, Your
That's
Lordship.
a different aspect. You're relying on the statements to show there is no ground, there is at any point of time, there is no default. So question of NPA doesn't arise, but your own documents speak.
Lordship, if some interim protection is given,
No
we'll
protection,
try
no
to
protection.
settle the matter with the bank, Your Lordship.
No protection. Come on Tuesday. We will straight away, that day, final orders will pass. No interim arrangements. Yes, next.
List number 3, serial number 1 adjourned, serial number 2, AS Ganesha.
Lordship, serial number 1.
1 is adjourned.
So they said some family emergency.
Oh, that's
That's what they said in the morning.
In the connected matter, we may be permitted to amend the prayer, my lord.
Only set aside, I have to include only word set aside
There
instead
is
of
nothing, it's
modify.
only dismissal of appeal for non-compliance of his objection.
Yes, my lord.
Give him the file, it is sent, it seems.
I will.
Yes,
Serial number 2, Ganesha case.
no notice, no representation on behalf of the petitioner, notice to the respondent.
Serial number 3, Yashwant Swami.
Yes, sir. Petition. Petition
Yes.
is enhancement, my lord.
What is the amount granted?
Wife, 5,000 is awarded, my lord.
What is the income of the husband?
Husband is the P1 of the BO office, my lord. Getting
How much is earning? How much is earning?
earning is as per salary certificate, my lord, admitted 26,000. Exhibit R1. The respondent is also admitted asset and liability, my lord. The trial court only considered 5,000 per month is lower side, my lord. The wife is the housewife, my lord, no income.
What is her age? What is her qualification?
2022 marriage, my lord.
That's what I'm saying. What is her age? What
Age
is her
22,
qualification?
22 years, my lord.
And what is
Petitioner-
she studying?
Respondent is 33 years, my lord.
Qualification. Qualification of the petition.
Qualification is petitioner is the second PUC, my lord. The respondent is the 10th. Yes, sir. Compensatory ground is appointed as a BO office.
It's not, it is truly 20,000.
No, my lord. Exhibit R1.
It is admitted that respondent is working as peon in BEO office at Chitradurga and is getting
Please.
monthly salary of 20,630.
Page number 3.
I'm looking at
number
para-
yes, please.
It's not 26,000.
Hello.
Court is right.
As on the date, my lord, the salary is, my lord, 35,236.
Where from you get all that?
Salary certificate of the respondent, my lord.
Where is it? You have to file the salary certificate. You
January
keep the certificate with you and you tell the court that is his salary.
After the filing of the RTFC, my lord.
That you have to file an additional document before the court. How can I consider like that? There should be something on record. And counsel for the petitioner submits that after filing of this petition, the salary of the respondent has increased and they'll file the salary certificate. List this matter on 19th of November.
Till number 4.
Yes.
Bandare.
It is awarded by the family court is 9,000 to the wife and 5,000 to the minor son.
9,000?
To the wife. 5,000 to the minor son, my lord. And my respectful submission is he is not earning more than 50,000 per month.
15,
my lord. 15.
Please come to the order.
Order portion which is in page number 27, my lord. Observation made in page number 26. Stated that he has a holding agriculture land, but all the property stood in the name of the father of the petitioner.
How many siblings you have?
One the sister is there, my lord.
What are the properties that your father is having?
Properties is ancestral properties. And
How many? What is the extent of land? What are the properties?
Land to the extent of 14 acres, 13 acres.
15 acres.
13 to
15 acres of land.
And all the revenue.
15 acres of coffee plantation, 5 acres of arecanut garden, and 5 acres of coconut plantation.
Total 16 acres, my lord. As per the, I calculated it as per the observation made in the impugned order, not more than 16 acres. And
according to you, 16 acres is like some 6
stands in the name
cents
of
of land.
this
Let
land
it
belongs
stand.
to
You
the
have
father.
you're also you own the you're also having the share in it, and your sister or whoever is married.
And my father also got two sisters, my lordship, and my sibling is another sister is there. It is a joint family property. They have claimed
Yes.
in seeking the reduction of the maintenance amount granted by the family court, my lordship.
You should make out some basis for that. You didn't even show what is the, you must be deriving some income. If you are genuine enough to tell that, then court would have considered. You simply deny saying that the property is with my father, I don't have anything.
And in my name, there is no property is reflected in the name of the petitioner, my lordship. All the properties are taken
You
care
also
by my
accept that
father.
it is a joint family property, you are also entitled for a share.
As of now, there is no income because the property is not yet allotted to the name of the petitioner, my lordship, and he is doing agriculture work.
File a suit. File a suit, get your property, you pay maintenance to the wife. Please come.
I have filed the petition for enhancement of the maintenance. On the ground that my father, he is he works as a writer in another coffee plantation, and he is getting salary around 50. My right now, he is looking after me, and the husband.
We will not go into the aspect what your father is
Yes,
doing and what
Yes.
he is contributing. You have to say what is the income and on what basis you seek enhancement.
Yes, right now, I don't have any income. I am a housewife,
Not your income. What is his income?
He owns 15 acres of coffee plantation, 5 acres of arecanut garden, and 5 acres of coconut plantation. And total, he is along with the father 45 lakhs is the income. And also,
Where from you get that?
in my
No, that is not all your requirements and assertions are not the.
in their
basis.
assets and liability, they have showed that there is a 15 lakhs loan is there. For getting a 15 lakhs loan also, that must be the property and income must be 3 times. Then only they can get a loan of 15 lakhs. And the petitioner here in the second matter, there is a small baby is there, she has to take care of the baby also. 9,000 is awarded in favor of the wife and 5,000 towards the baby. And the present right now, she doesn't want to be a burden to his father, and she wants to lead an independent life. The husband, he is having an affair with another lady, and he goes to the to that house in Panampet. He comes, returns in the midnight, and there is a lot of misunderstanding between husband and wife, and there is no any chance of reunion. Hence, the amount what is awarded in favor of the petitioner, that has to be announced, so that she can live a rented independent house.
Unless and until you say what is the definite income, we can't enhance it. 15,000 is reasonable under the tax. Please come. Agreed with the orders passed in criminal miscellaneous number 142 of 2023 dated 5th February 2025. Whereby the child court has granted 9,000 to the wife and 5,000 to the child. The husband is before this court seeking enhancement of the compensation by filing RPFC number 171 of 2025. And the wife had filed RPFC number 264 of 2025 seeking enhancement of the compensation in 4.1 IA order. IA number 1 of 25 is filed to condone the delay of 128 days. For the reason stated, the delay is condoned. The wife has filed a petition seeking maintenance of an amount of rupees 25,000 per month. It is the case with the wife that the husband and his father are having 15 acres of coffee estate, 5 acres of arecanut garden land, and also 5 acres of coconut plantation, and earning more than rupees 20 lakhs per year. And the petitioner is the husband is the only son to his parents, and is also doing business and is earning more than 50,000 per month. And is also having 3 four-wheeler vehicles and also owns a house in the coffee estate. and the wife is not having any source of income. It is the case of the husband that
He is working as a part-time driver as per his assets and liabilities.
where did you say about your, where are your statement of assets and liabilities? The court has also not extracted.
My lordship. But it is extracted in the evidence.
Evidence, my lord, it is forthcoming in the evidence.
No, I'm saying court, there is no reference in the order.
There is no reference with respect to the assets and liabilities filed by both the parties, my lord.
What is your case?
My case is I am working as an part-time driver and earning not more than 6,000, my lord. ನಾನು ಮಾಡುವ ಕೆಲಸದಿಂದ ತಿಂಗಳಿಗೆ ರೂಪಾಯಿ 6,000 ಆದಾಯ ಬರುತ್ತಿದ್ದು ವಾಹನ ಮಾಲೀಕರು ನನ್ನ ಕೆಲಸಕ್ಕೆ ಕರೆದ ಸಮಯದಲ್ಲಿ ನಾನು ಚಾಲಕನ ಕೆಲಸಕ್ಕಾಗಿ ಹೋಗುತ್ತೇನೆ. Only say that whenever the owner asks for the driving, he went there and.
The case of the husband that is earning.
Do his driving work, my lord.
He's working as a driver.
Part-time driver.
Part-time driver and earning 6,000 per month.
6,000 per.
Part-time driver and earning 6,000 per month. It is so the court considering the fact
and also
that
all the properties belongs to the father
and
of
the properties belong to the father, and so far no share is allotted to him. The court considering the fact that the family owns an extent of more than 25 acres of land, had granted maintenance of 9,000 to the wife and 5,000 to the child. And then counsel for the petitioner, wife, not petitioner, then counsel appearing to the husband submits that the court, when his income itself is 6,000 according to him, and when there are no properties in his name, the court ought not to have granted the maintenance. It is submitted that the amount of maintenance that is granted by the court is excessive and is not in a position to pay. Next, land counsel appearing for the wife submits that wife and the child have to live with this amount of 15,000 and the amount that is
14,000.
Huh?
14,000, 9,000
14,000 and which is on the lower side. It is submitted that the husband is having all the family is having these properties and his only son, and they are deriving an amount of rupees 40 lakhs per month.
45 lakhs.
45 lakhs per annum. And in those circumstances, the court ought to have granted a reasonable amount as maintenance. It is submitted that the writ petition needs to be allowed by enhancing the maintenance expenditure. But the counsels on either side, there is the material on record. According to the wife, the husband is earning 40 to 50,000. There is no evidence in that regard. There is no evidence in that regard. However, the husband do not dispute the fact that there are properties, family properties, though it is not in his name. That aspect is not denied by the husband. When he is having all these properties, why he is working as a part-time driver is also not known and appears to be, and also not believable to such a statement. Considering all these aspects, the court had granted 9,000 and 5,000, that is 15,000, and this court finds no reasons to reduce the compensation. When it comes to the enhancement also, to enhance the compensation more than that, there is no other material. Hence, both the petitions stands dismissed. Already order is passed. Yes. In not necessarily in 4.1, though the land counsel Mr. Girish Bandare, who has filed the RPFC on behalf of the husband, submits that instructions to represent in the second matter. Yes. Yes.
List number 4 for being spoken to, serial number 1. List number 4, serial number 1.
What is it?
Para number 8, kindly see.
Judgment para number 8.
Yes. Yes.
The accident had taken place in the year 2020.
Hmm.
And as per the chart, this court is taking income at rupees 40,500. Considering the age of the deceased as 47, the future prospect at 25% would be come to an amount of rupees 18,125. As there are 5 claimants, 1/4 has to be deducted towards the personal expense, which comes to rupees 7,250 is wrong. After deducting the 18,125.
No, 1 minute. 14,500 into
Plus future prospect.
25, please wait, divided by 100 is 3,625. 3,625 plus 14,500. It comes to 18,125.
Yes.
125. Then we have to, in that, how much 1/4 has to be deducted?
1/4.
Into 1 divided by 4 is 4,531.
Yes.
To the family would be 4,000. Oh, it is instead of
Calculated. Page number 2.
Yes. 4,531. 4,000. It comes to 13,594 into 12 into 13 is 21 lakhs 20,664 plus 2 lakh 20,000 it comes to 23 lakhs 86,664. Correct?
30% contributory negligence should deduct. 30% contributory negligence.
So you're entitled for 70% of the amount.
Yes.
It comes to 16 lakhs.
16 lakhs 70,665.
664. Please come. Matter is paid before this call and the caption for being spoken to. Then counsel submits that while deducting it is submitted to the court at taken 14,500 as the income and 25% is deducted. 25% future prospects are granted. It comes to 18,125. While deducting 1/4. Instead of deduct the 1/4 of 18,125 comes to 4,531, but the court had deducted 7,250. Hence, the present petition is filed. 18,125 plus future prospects. The 1/4 is deducted. It comes to 4,531. And the contribution to the family would be 13,594 into 12 into 3. It comes to 21 lakh 20,664. And the total compensation would be 23,86,664. 664. 664. As there is 30% contributory negligence is fixed on the claimant, the insurance company is liable to pay 16,70,664. Accordingly, the order copy shall be corrected. I have marked in that. I have marked in that where I have to be corrected. Yes. Next.
Till number 2 for dismissal.
As for appellant, issue
Yes.
notice to the respondent number 1.
I'm for the appellant in 2.1 months.
Hmm?
I'm for the appellants in 2.1. We have complained the office objection in last date.
Office objections raised on PF to furnish one set.
Please, ma'am.
Have you served the copies on them?
Yes, already served.
That's what I posted it for dismissal.
Already sent through WhatsApp. Long back.
That's what they represented, that it is not served. You were not there, that's why matter is listed for dismissal.
I served to the
Serve a
senior.
copy. Then counsel for the applicant shall serve the copy of the appeal memo on the counsel for the respondent. Then in 2.1, who is R4?
R4 is harmony.
Owner.
The
Owner of the vehicle.
the petitioner, the appellant shall comply with the office objection, shall do the needful within a week.
Copy sent to the WhatsApp on 11 August 25.
That's what she's representing. Anyhow, let's not go into all that.
Already
Give them
served.
on a copy.
No,
Yes,
what is
next. In this notice is necessary to R1
Not us.
in your case.
Challenging the liability.
But in your case,
No,
not necessary.
Not necessary.
Then give a memo. A memo is filed seeking dispensation of notice to R1. Dispense to it. Yes.
List number 3. For orders matter, sale number 3. Sale number 3.
No, for them it is not necessary because it's a claimant's appeal. Where is the order in this case? Please come. This court on 8th November 2023 has disposed of the appeal, directing the MACT this court has set aside the order and directed the MACT to hear the matter, to dispose of the matter within 6 months. The court shall, and also directed that the court shall issue notice to both the parties and shall decide the matter within a period of 6 months from the date of receipt of the copy of the order. And the registry is also directed to return the trial court records to the tribunal along with the certified copy of the order passed by this court forthwith without any delay. The registry shall place before this court. The registrar judicial is directed to place before this court. On what date this order is sent to the tribunal, MSCT. Now, a letter is addressed on 8/9/2025. That is after 2 years, nearly after 2 years, a letter is addressed by the judge seeking another 6 months time, stating that due to oversight, the matter was brought to the notice of this court on 14/8/2025. Will this matter on Tuesday? Yes. Memo is filed seeking dispensation of notice to R1. Dispensed with. What is this memo? Why is a memo moved?
Notice has to go to our R2.
R2 is Reliance General.
You don't comply the office objection.
It's already done, my lord. It's
And you
already
file a
done.
memo
It's
and
already
the court has no other work to every day to give the dates to the memo.
I'm sorry, my lord. It has been done, my lord. Needful has been done. Notice has to go to R2 also.
Memo is filed seeking dispensation of notice to R1. Who is R2?
Reliance
Who
General.
appears? Reliance General Insurance.
Reliance General, sir.
Mr. Ashok and Patil is directed to take notice on behalf of the insurance company.
R2.
Any other respondents?
No, my lord.
Admit post of final hearing, call for the TCR. Yes, 5.
5.
I'm wondering why all these memos are being moved like this.
R2 insurance company of the universal company is not served matter that address criminal is taken notice.
Who appears for that? Sivanagowda is directed to take notice on behalf of the respondent insurance company. I number 1 of 24 is filed to condone the delay of 226 days in filing. Condone. Admit post of final hearing, call for the TCR.
Then number 6, Sarita Kulkarni.
For the application, notice has to go to R2. Needful has been done.
I think I will impose costs on you on this matter. And I do not, I'm telling the advocates, don't give the memos like this. What is the urgency for these memos like that without even complying with the office objections? Because court is granting liberally. Who is R2?
R2 is
Reliance General.
Yes, Mr. Patil is directed to take notice on behalf of the insurance company. Or what about R1?
R1 is notice.
Dispense with this, admit post of final hearing, call for the TCR.
Tell number 7.
I appear for appellant, my lord.
Kumar.
My lord, there is objection with regard to maintainability, my lord. It is a belated application, my lord, filed by the claimant under 166, my lord, claiming compensation along the delay application, my lord. My delay application came to be dismissed and order 7 to 11 application filed by the insurance company allowed, my lord. That is under challenge before the court, my lord.
In an
Challenge-
appeal. What is impugned, please, let's see.
Well, impugned, my lord. Can you see, my lord? I filed the application seeking to condone the delay in filing application, seeking compensation. On the other hand, my lord, the insurance company filed order 7 to 11 day application seeking to reject the petition, my lord, which came to be allowed. My application seeking condonation of delay is rejected, my lord, dismissed. That both the orders under challenge before the court, my lord.
Who appears to the respondent? United India Assurance Company. Who appears? Mr. Krishna Kishore is directed to take notice on behalf of the. No, this office of when the rejection is allowed, he has to prefer an appeal against that. Mr. Krishna Kishore. The insurance company has filed a petition for rejection of plaintiff. I mean rejection of the petition. That is allowed. That is allowed. Order 7 to 11 is allowed.
Writ petition has to be filed. Writ petition has to be filed.
How can it be?
Appeal is maintainable, my lord.
Appeal procedure is there. Appeal. We have to file appeal.
Appeal only. It has to be a regular appeal. The office objection with regard to the maintainability is why it is not maintainable? Yes, Mr. Shivanagowda.
The delay application is rejected, my lord.
No, not delay application. By virtue of an application being allowed, order 7 to 11, what happens? Nothing remains. Then it's even in the under CPC also a regular first appeal.
That's what,
And in respect of this is a
what
miscellaneous
has happened,
appeal.
my lord, in the writ petition which we have prepared, where, my lord, our application has rejected and the delay application was allowed. Though, so
That
claim
was a-
petition is continued, therefore writ petition.
Interlocutory application.
This is also correct, my lord. What he has filed is exactly correct. Appeal is made.
No. For example, if this order 7 rule 11 is rejected,
Correct.
then in the
writ
writ petition lies
correct.
under 227.
Correct.
The office objection with regard to the maintainability is overruled. Mrs. Swayam is directed to take notice. Who are the other respondents?
The owner, my lord.
Notice to the, which respondent he is? First respondent.
Respond number one, my lord. Respond number one.
Petitioner, the appellant shall serve the copy of the appeal memo on the counsel for the appellant insurance company. List after service of notice. Yes, next 8.
Appeal for appellant in this matter, please, my lord. R1 is the owner of the vehicle, please, my lord, filed a memo for dispensation of service of notice to R1, my lord. It may be considered, my lord. On 4/9/25, we have filed memo.
Okay.
Giving process to R2, we have filed memo along with the process memo.
It is submitted that a memo is filed seeking dispensation of notice to R1 registry is put up, directed to put up the same. This is matter on 11th November. Yes, 9. This is matter after service of notice. Next.
Insurance company challenging on the ground liability, my lord. Act policy issued, my lord. PA coverage not covered.
Give that.
Serial number 9. Seeking stay, my lord.
It is an act policy.
Please, my lord.
What is the finding of the tribunal?
Criminal liability fixed against the insurance company has to pay liability.
How it has dealt with it?
The PA coverage not consider PA coverage not paid. Only act policy has been used. Liability only policy.
That's what I'm saying. Where is the consideration of the court on that? What is your contention?
Policy issued on the act policy 164 claim petition.
Where did you say so?
Para number, my lord. 5, my lord. The respondent further contended that petition is also maintainable under 163 fact circumstance. The present case is the provision of 163 only, applicable with third party provision of the under full.
Counsel with the petition, appellant submits that the insurance company is not liable to pay the compensation. The company is on the ground of liability, which is not considered by the court. Considering the submission, they shall be stay of all further proceedings on the condition that they shall deposit 50%, no withdrawal permission. No permission to withdraw. Is
Before this court, my lord. Before this court, we will.
Wherever you want to deposit.
Please, my lord.
Serial number 10. Sarita Kulkarni.
I'm looking for the respondent to enter corporation.
The managing director KSRTC Davangere.
577.
R2 also you take.
R2 and 3.
For R2 also, Mr. M. Ashok Kumar submits that he has instructions to file vakalat. I number. You want to file the?
You already filed vakalat.
You already filed.
On
I number 1 of
July
24 is
2025.
filed to condone the delay of 577 days. The respondents have filed that. For this also another memo.
My lord, connected with this file. Trial court records has to be.
I'll give them a standard instruction that not to list your matters and not all your memos to be not considered. Please don't give memos like that.
Today.
And number 1 of 24 is filed to condone the delay of 577 days. The respondents have filed their objections. It's an appeal filed by the claimant, balancing the interest of both the parties. This court deems it appropriate to condone the delay of 577 days on the condition that they are not entitled for interest. Yes, admit post of final hearing. Call for the TCR.
11.
Yes,
Filed application for withdrawal of amount.
I number 1 of 25 is filed. So you can withdraw the amount deposited by the appellant. The IA is allowed and the
In terms of award.
liberty to
In terms of award, because 18 lakh and order, we have required.
is permitted to withdraw the amount as per the conditions stipulated in the award. I number 1 of 24 is filed to condone the delay of 41 days in filing. Condone.
Much of it.
Yes, admit post of fund.
Bill number 12. 12.
A number for recalling one. Recalling dated 5/8/2025 for a non-prosecution.
So why should we recall? Why you were not there before the court?
Not keeping well on that date, madam.
The appeal was filed in the month of November 2024 until no office objection is not complied. Also, there is no representation that the appellant is not interested in pursuing the matter. Therefore, the appeal stands. I number 1 of 25 is filed to recall the order dated. Have you complied till now?
Till now, not compliant.
Pending consideration of I number 1 of 25. The petitioner, the appellant shall comply with the office objections by 28th of October, or else the IA 1 of 25 will not be considered by this, stands dismissed. Yes.
Bill number 13.
For appellant, the appeal was dismissed for non-compliance of office objection, my lords, on 4/8/25, my lords. What was happened, my lords, at the time when the case was called out, I was held up in some other court, my lords. By the time I reached, the case was already called out.
What is this all second round now?
No, my lords.
All recalling orders.
My lords, only one office objection was there, my lords, that is to file delay application, my lords. I have already filed it. I have filed it, my lords. I have filed it on 17/10, my lords. 17/10/25.
When was it dismissed?
It was dismissed 4/8/25, my lords.
I number 2 of 25 is filed to recall the order dated 4/8/2025. So the reason stated, the delay, for the reason stated, the I number 2 of 25 is recalled and the appeal is restored to file. Even in the other order also. In the other order also, the appeal is restored to file. Then you are not pressing IA 1 of 25.
No, my lords, that is for
The IA number 1 of 25 is dismissed as not pressed.
notice.
Who is the respondent?
Respondent number 2, New India Assurance Company. New India Assurance.
Who appears?
For R1 dispensation memo.
Our memo is filed seeking dispensation of notice.
R to R1.
R1.
R2 is New India Assurance Company.
New India Assurance. Mr. C.R. Ravishankar is directed to take notice on behalf of the respondent insurance company and counsel the appellant to serve the copy of the appeal memo. Admit post for final hearing. Call for the PCR.
Please, ma'am.
I for 5/6/5/8/2025 5/8/2025 not prosecution. Same.
So every day will not appear before the court.
Same day is not keeping well.
Same, this order also. I number so and so for the respondents. In 12 also, take for 12, only IA is recalled. What about the notices in that? So that's okay. Take 12 also once. KSRTC, Mr. Zabali is directed to take notice on behalf of the respondent. Admit post for final hearing, call for the PCR in 12. Then in 14 also. 14. R3 is United. Mr. Ravish Beni is directed to take notice on behalf of the respondent. What about 1 and 2?
Dispense, file.
You filed already.
Illa, no madam.
Now we will file. A memo is filed seeking dispensation of notice to 1 and 2. The notice is dispensed with the risk of appellate, admit, post for final hearing, or for the DCR.
15.
Appellant, corporation appellant. Matter. The first application is the dispensary application. The other certificate copy is filed on 16.
Why the certified copy of the judgment to be dispensed with?
Because I filed a original certificate copy filed on MFA 6647 of 2022.
IA number 1 of 22 of 25 is filed seeking dispensation of certificate copy of the judgment. It is stated that they have filed the certified copy in the other appeal. Next.
Kindly grant the stay.
What is this? The grant stay provided to tell the court what is this case about?
The driver, there is no negligence of the driver of the case at this first.
That is a general.
No, at the time of the driver of the auto, he himself.
Who against whom it is filed? The charge sheet is filed.
Charge sheet driver.
That
Because
is
of
general.
this, the fact is that.
KSRTC general submissions in all cases.
No, my lordship. In this
So
case.
what is the amount granted?
Amount granted. Total amount 3,50,008.
Where is which MBC is this?
MEC number 5813 of 2023. 5813 of 2023.
5813.
Serial number 14, 15, serial number 15, 16, 17 are all the connected matters. Serial number 15, 16 and 17. All the connected matters.
So please tell the court in 15, which is the MBC?
If you are still on 15, 5813 of 2023.
5813. Where will you get the amount?
Synopsis. Total amount 3,50,800 rupees. They are is awarded.
3 lakh?
57,800.
Deposit 2.5 lakhs.
I already deposited my
How much?
1,74,896.
The appellant, it is submitted that there is contributory negligence on the part of the, that there is no negligence on the part of the driver of the KSRTC. Considering the submission, they shall stay of all further proceedings on the condition that they shall deposit 2,50,000 on within 8 weeks and do the remaining one also. And on such deposit, the insurance, the claimants are at liberty to withdraw. Notice to the respondent.
Till number 16, same.
Connected matters.
How much is the amount in this?
That one. 7,67,700. 7,67,700.
In this matter, in this matter, 5 lakhs.
4,03,000 I deposited.
When you deposit? Yes, 17.
17.
How much it is?
In this case, 7,32,300.
In this also 5.
I am also in this matter.
Yes, next.
Till number 18.
And all the three cases.
Stay granted.
Club same judgment. All three matters same judgments. Claim the club the matter. Same judgment.
Oh, the dispensation. Club all these 15, 16 and 17. What is next? 18.
Till number 18.
Paper
Jay Kumar P.
Notice
payment
to
of
the
bill for
respondent.
enhancement alert. R1 notice will be dispensed.
Memo is filed seeking dispensation notice to R1. Sompo General Insurance.
Universal soap.
And let me look at it. Only one name is there, Sharanappa Kauda Malipat.
Universal Sampa, I can take notice, madam.
I am there. Pradeep is also
Then
there.
give the latest list.
I don't know who has given that list.
All the councils of the insurance companies give the latest list. It doesn't have all the names. Only one name is there. Kauda is directed.
Madam, Universal, I am also there, my lord. I may kindly be taken notice.
Mr. Mr. Shivana Kauda is directed to take notice on behalf of the insurance company. One dispensed with. Notice is completed. 107 days delay condoned on condition. Next 19.
Till number 19.
Sriram General, who else appears apart from both of you? Only two of you?
No, 3, 4.
Who are other two?
Sitaram Rao,
Ah.
Krishna Swami.
Sita Ramarao is directed to take notice on behalf of the respondent insurance company. Who are the other respondents?
Anup Sitaram.
Anup Sitaram. A memo is filed seeking dispensation of notice. A delay of 135 days condoned on condition. Next 20.
Case number 20.
For appellant, my lords, delay of 434 days is there, my lords. Insurance company is not made as a party before the trial.
Oh, notice to the
Notice
respondents.
to respondents.
21.
21. Article ICICI number. Syed Abdul Sabur.
Where is he? What is the company?
Article ICICI number.
Mr. Shivanagoda is directed to take notice on behalf of the respondent insurance company. Notice to R1. Yes.
Case number 22. Article is United Indian Insurance Company. Syed Abdul Sabur. R1 to R3 are there.
Mr. Sri Shaila S is directed to take notice on behalf of the respondent. R2. Notice to R1. R1 and R3.
Case number 20. There will be there. Notice. Case number 23. KL Srinivas.
Appellant on behalf of KL Srinivas, my lord, sir. R2 is the new name.
National Insurance Company.
National Insurance Company, my lord. R1 is the dispensation of notice to R1. Shivanaguru.
Mr. L. Srikanth Rao is directed to take notice on behalf of the respondent insurance company. Memo is filed seeking dispensation of notice.
Already filed.
R?
R1.
R1. There's the IN number 1025 is filed to condone the delay of 797 days condoned on condition. Admit post of final hearing all, wherever delay is condoned, admit for final hearing TCR.
Memo for dispensation of notice to R1. R1 may be dispensed.
Hmm.
NIC, National Insurance Company.
Same connected matter?
No, ma'am. Different matters. Different matters.
National Insurance Company.
National Insurance Company.
Ask for a new list. Ask them to get the Mr. M. Arun Pannappa is directed to take notice on behalf of the respondents. Memo is filed seeking dispensation of notice to R1, dispensed with delay of 203 days, condoned on condition, admit, final hearing.
25. R2 is report of it. R1 and 2.
R, if court of case wishes for it.
R2.
Mr. S.V. Hegde Mulkand is directed to take notice on behalf of the respondent to one in notice to R1 and 3. R1. Yes, next.
Serial number 26. Sole respondent case. BMT.
BMT. Who appears for the BMTC?
Gurudap Prasad.
Lord, 3,32,221 with accrued interest. Please, within 4 weeks, my Lord, I will deposit. Grateful.
Serial number 4, 34.
Please.
I'm filing dispensation for R1. My lord, 7 days delay may be kindly come. Oblige me.
Notice may be dispensed against R2 mill. I'm filing name.
Video not visible.
Thirty-seven.
P. Suresh appear for appellant. P. Suresh, Mr. P. Suresh appear for appellant for enhancement bill.
Yes. I am filing memo for a dispensation against R2 mill. Appear for appellant, madam. I am filing memo for dispensation against the respondent number 2. 2.
P. Suresh appear for appellant, my lord. R2 may be dispensed with, my lord. If court document. Shankar Reddy is there, my lord.
Insurance company is an appeal challenging the on ground of liability, your lordship, that is on the ground of involvement of the vehicle, as well the petitioner had consumed the alcohol beyond the limits prescribed under section 185 of MV Act, your lordship. 13 lakhs 24,048, your lordship. And also non-involvement.
Lord, I'm appearing on behalf of D. Vijay Kumar. I'm told it's an insurance company appeal challenging liability. There was a delay of 2 years in filing the claim petition in the lower court, and there was 31 days of delay in filing the complaint. So he has challenged the liability. So I'm paying for stay on behalf of Mr. D. Vijay Kumar. in another court.
Court video not coming, my lord.
Yeah, I'm told that it's a case where he's challenging liability. I don't know, my lord, but 50% is ready to deposit. I'll just communicate it to him, my lord.
For appellant, my lord, I am filing memo to dispense the notice to respondent number 2. Tata Age. Sure.
43 appear for the appellant in this case, my lord. Kindly delay may be condoned, my lord. Sorry, my lord.
Appear for appellant counsel, my lord. R2 may be dispensed, my lord. Cholamandalam, my lord.
Appear for the appellant in this case, my lord. Now for dispensation of notice to R1 and R2, my lord, sir. 2. United Indian Insurance Company. Best, it's the bits. Bits, sir. Bits, sir. Bits. This. This. Blood. Now for dispensation of notice to R1, blood, sir. R1. R2 United Indians. Please. Please. Oh. Please.
R1 may be dispensed from owner of the vehicle, R2 HDFC. EFC. BC Sivanaguru. Yes. That is the reason I don't know who has given that list to Lordship. I will. I don't know.
Now for dispensation of notice to R1. Oriental Intelligence.
For appellant, my lord, R1 may be dispensed, my lord. R2 is if court okay. R3 is also necessary party, my lord. Liability on R3 also 25%. R2 is insurance company if court okay, me. Allah sorry, ICICI number, ICICI number.
In 51, I pay for the appellant in this case, my lord. Kindly notice may be issued, my lord. Pradeep sir is there. Pradeep sir is there, my lord. Pradeep sir is there, my lord. Please, my lord.
By Monday, give the updated list of all the councils, please.
Much obliged, my lord.
52, my lord, Acco General Insurance Company, my lord, R2, my lord. Pradeep is there. Pradeep. R1, my lord, I will kindly issue notice, my lord.
I'm for the appellant, my lord. I'm for the appellant, my lord. And notice may be issued to Oriental Insurance Company.
BFTC. BFTC. The one.
R1 may be dispensed, my lord. Minute.
Notice to R1 may kindly be dispensed. New India, my lord, insurance company also filed an appeal. P. Ravishankar may be directed to. For R. My lord, 2834 of 25. Please.
United India Insurance Company, my lord, sir. R1 is the owner of the vehicle, maybe. Dispensation of notice to R1. United India.
Second respondent is the owner. Notice may be dispensed. Yeah.
Appellant in this case, my lord, KSRTC only.
Appellant, my lord, KSRTC. One more appeal preferred by the KSRTC, my lord. G. Lakshmish Rao, my lord. G. Lakshmish Rao. No, my lord, in time. They have filed in time, my lord. Please.
I'm for the appellant, my lord. I'm for the appellant, my lord. They are, R1 is abated in trial court itself. So, no, ma'am. In the judgment itself, it is abated. No more. That's why insurance company is the respondent. Yeah. Oriental Insurance. Ma'am. Yes, ma'am. Same. Same, ma'am. No, ma'am. Seeking dispensation. R1, yes. United in.
For the appellant, Your Lordship. There are 54 days of delay in this filing the appeal. No, for R1, it may be dispensed, Your Lordship. I'll file the memo.
$66 million R1 notice may go. R2 is a New India Insurance Company. Right? Yes, my lord. 67 also same, my lord, connected matter, my lord, arising out of same action.
68, my lord, notice to first respondent. Lord, R2, my lord, Bharti Exa. Merge with ICIC, my lord, BC Shivanegoda may be directed to take notice.
Your Lordship, notice to R1 may be dispensed because he is placed ex parte. I'll give it. Okay.
Appellant, R1 notice may be dispensed with, my lord. R2 is Bajaj General Insurance. Please.
Notice to R2 may be dispensed. R1 Royal Sundaram. Ravis. Sunandro. Ravi Samprati may be there. Ravi Samprati may be there. '72 also. R2 may be dispensed.
I am for applying my insurance company challenging on the ground of quantum miles. I am filing dispensation respond number to owner of the vehicle. My compensation award case of injury, my lord, awarded 7,09,655 rupees. He is continuing same job, my lord. I will deposit 3 lakh rupees, my lord. If they can permit to withdraw 2 lakh rupees, my lord. Not future purposes, future loss of earning. Please, my lord. Before this court, my lord. Please, my lord.
I'm for the claimant, my lord. Date of 17/8/2019, my lord. Petitioner's son has deceased, my lord. Can be.
Notice to R1 may be dispensed. The insurance company has deposited your entire amount. 76. Yes. Yeah, I'm representing the entire. No, the insurance company have deposited the entire amount before the trial court. The amount may be released here. No, they deposited the amount and they filed a memo not to release in trial court. Kadur. EC entire amount they have deposited together with interest.
Which case, sir? The EC?
No, EC.
Normally, under the EC Act, I need to deposit entire amount before the court, before filing the appeal before this court. I don't know whether insurance company has filed the appeal or not.
No,
there is a judgment of this Honorable Court, my lord, after deposit of 2 months, up to 2 months, that amount should not be dispersed, giving the opportunity for the insurance company to challenge.
Why should they take action from this court to release that amount?
No. That is
direction not to release in law.
correct.
Why will there be a direction in his appeal to release the amount?
Because they have filed a memo.
Forever, the court will not stop. So with the reasonable time, after the appeal time is last.
Reasonable time.
Yes, sir. Yes, sir. New India. Mr. Ravish, Benny is appearing. No, sir, Benny is appearing. Benny is appearing, right?
Claimant's appeal, madam, case of injuries. Notice to R2 may be, R1 may be dispensed with members. New India, National Insurance. Notice to R1 may be dispensed with, my lords. Cholaman.
79, my lord, in this case, my lord, the claim petition dismissed, my lord. Arising out of same extent, my lord, other claimant file appeal, my lord, other case, my lord, Janardhan Reddy appeal, my lord, for R2, my lord. R1 issue notice, my lord, R1. 80, my lord, in this case also, my lord, claim petition dismiss. Other matter, my lord, Shriram General Insurance, my lord, Shivana Gowda appear, my lord. R1 kindly issue notice, my lord.
Respond number 2, notice may be dispensed with, my lord. Respond number 1, Reliance General Insurance Company, my lord, please.
Claimant's appeal, my lords. And for the appellant, my lords, case of death, my lords. Notice to R1 may be dispensed, my lords. Kindly, I may be permitted to file it in the ICICI, my lords. My lords, may I be permitted to file the dispense memo at the registry, my lords? Please, my lords. Please, my lords.
Appearing for appellant, the notice may be dispensed to R1. ICICI Lombard.
R2 may be dispensed, my lord. Bajaj Alliance R1 bill. R2 dispensation memo file.
For the appellants, my lordship. My lordships, R1 and R2 are formal parties, my lordship. It may be kindly dispensed of. We'll file it in the counter, my lord. Yes, my lordship. And R2. HDFC, my lordships.
In this case, my lord, claim petition dismissed, my lord, kindly issue notice to R1 and R2, my lord. R3 is a Tata AIG, my lord. Pradeep is there. Pradeep is there, my lord.
Appearing for appellant, my lord. Appearing for appellant, my notice may be dispensed to R1. United India Insurance.
Dispensation, man. Please. Notice to R1 make. Shriram General B. Pradeep. 91, my lord, R1 may be dispensed with, my lord. Please, please.
Please, my lord.
91 also. 91, my lord. MS Cholamanda Bajaj 91 Cholamanda. 90, my lord, Shriram. Cholamandam B. Pradeep, my lord. Bedsur. 92, my lord, Bajaj.
Please. P. Pradeep is appearing.
Please. 93, my lord, Chola MS General Insurance Company. Please. Who also given? Please. Please. All the cases are. 93 also Chola MS General Insurance Company. V. Pradeep is appearing.
Claim petition was dismissed, so notice may be issued to R1 and R2. Magma.
SV Hegdem. SV Hegdem.
My lord, I am appearing in this case. New India Assurance, my lord. R1 to be dismissed, my lord. I'll file necessary memo. New India Assurance.
97.
95,
97. I am here for the respond, my lord. I have filed the application withdrawal of the amount, my lord. The value, my lord, my lord, post along with my lord, I have filed the enhancement appeal, my lord. 6/12 of 2020. My lord, Monday is along with my lord, it will dispose of matter, my lord. Kindly 97, my lord, post along with my lord.
98, my lord, enhancement.
I am for respond number 2, my lord.
Claimant's case, my lord.
I am for
My
respondent.
lord, this is a case of child death, my lord. A 6-month old. Please, my lord.
6 months, my lord. 6
old
months.
male
As per
baby.
Kishan Gopal, the learned MHCT has been considered, my lord. Kishan Gopal
My
is
lord, recently, my lord, in August 2025. August 2025, my lord. It has awarded 8,70,000, my lord. The Supreme Court.
that is a 10 years.
Child,
10 years, my lord.
10-year-old, but then the Supreme
in
Court
this case, my lord, that
says,
related
my
that
lord,
this is
that
6 months, my
inflation
lord.
has to be considered. Please. Please. Please.
Case of injury.
I appear for respondent number 3.
Too many matter. I beg a pardon, my lord. PF. I beg a pardon, my lord. PF. I think in 2 of the matters, DCF was there.
We thought.
I had instructed my colleague to look
We
into
thought
that.
different dates may be given, my lord. That is.
By then, anyhow, we have paid the PF. Now, my lord, in this matter, service is already. Yes. My lord, when we have pressure from the parties also, my lord. Kindly appreciate. Next matter, 100, my lord, TCR, await TCR, my lord,
100 next matter. 100.
Obliged.
What up, sir? What up, sir? What up, sir? Madam, Court Officer. Court Officer. Court Officer. Court Officer. Court Officer. Madam, Court Officer.
ಹೇಳಿ ಸರ್.
Madam, 95 and 96 ಏನಾಯ್ತು ಮೇಡಮ್? 95, 96 serial number. Serial number 95, 96 madam.
ಹೇಳಿ ಸರ್.
Madam, 95, 96 ಏನಾಯ್ತು ಮೇಡಮ್?
1911 ಡೇಟ್ ಹೋಯ್ತು ಸರ್ ಅದು.
ಹೌದು
ಮೇಡಮ್ ಸೀಲ್ ನಂಬರ್ 75
ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆ ಮೆಮೊ.
ಸರ್ ತಗೊಳ್ಳಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 82 ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್. ಮೆಮೊ ಬುಕ್ ಏನಿದೆ ಸರ್?
ಬೆಳಿಗ್ಗೆ ಮೆಮೊ ಮಾಡಿ ಸರ್, ಡೇಟ್ ಇದೆ.
ಮೇಡಮ್ ಸೀಲ್ ನಂಬರ್ 75
ಹೇಳಿ ಮೇಡಮ್. ಎಲ್ಲ ಪೈಸೆ ಇದೆಯಾ ಮೇಡಮ್? ಅವೆಲ್ಲ ಡಿಸ್ಪೋಸಲ್ ಸರ್ ಕಡೆ ಇಟ್ಬಿಟ್ಟು ಸರ್ ಫಸ್ಟ್ ಬಂದ್ರೆ ಅವ್ರಿಗೆ ಪ್ರೈಸ್ ಕೊಟ್ಟಿಲ್ಲ, ಇಲ್ಲೇ ಇದ್ದೀನಿ.
Madam, respond.
ಲಿಸ್ಟ್ 4 serial number 3 ಏನಾಯ್ತು ಸರ್? ಹಾ
87 ಅಲ್ಲಿ ಪ್ಯಾನಲ್ ಅಡ್ವೊಕೇಟ್ ಹೆಸರು ಶ್ರೀಕಂಠ
ಅವ್ರು ಬಂತು ಸರ್ ಅದು. ಓಕೆ
87 ಅಲ್ಲಿ ಯಾರು ಸರ್? ಸರ್ 87 ಅಲ್ಲಿ ಯಾರು ನೋಡಿ ಸರ್ ಪ್ಯಾನಲ್ ಅಡ್ವೊಕೇಟ್?
94 is going. It's very crowded also.
ಸರ್ ಕೋಟ ಪುಸ್ತಕ ಕೊಟ್ಬಿಡು.